มาเทสลามเลยก็ได้ครับขอ English Channel ครับGood job ครับขอเป็นไทยครับไทยโอเคครับเดี๋ยวมันเสียงดังกว่านี้ได้ปะเสียงมันเบาจังใช่โอเคขอบคุณครับจอยล่ามยัง7
จอยแล้วปกติใครไปแอสไซน์อ่ะ
อ๋อก็บอกแล้วยังโปรโมทแล้วโปรโมทแล้ว
โอเคครับขอโล่หน่อยเดี๋ยวเดี๋ยวพี่ขอเทล่ามในซูมนะ
Barengan delegasi nih. Oke. Biasa urusannya sama.
Okay.
Siap. 1, 2.
Wait.
Oh, sorry.
Okay. Sorry.
Okay.
Thank you.
1, 2. One more. 1, 2.
Thank you,
With
Pak.
yours? Yeah. Kenapa? Video. Oke. Oh, nggak mau foto lagi?
Okay. Okay. Thank you.
Okay.
Judge, let's sit
Okay.
together, together. So this is the advantage, Judge, if when we're early. I understand you're a judge here in San
Over
Juan.
here.
I met you last time.
Over here, yeah. So in the middle. Yeah.
We are speaker.
Okay.
Yes.
One, two. One more. One, two. Okay.
Thank you very much.
Thank you.
Thank you very much.
Can you take the picture from here?
Yes, I will.
Stand there.
You can be on the podium.
Yeah, yes, yes, that's what I mean. Yeah, please take. Can
Okay.
you a picture over here?
Okay.
Yeah.
Oh. Smile.
Okay.
Okay, one, two, and another.
Yeah. Okay, thank you.
Evidence. One, two, and another. Me too, Judge. Me too movement. We like little kids. Here you go. Okay. Yes, but you have to. That's like that. Okay. Hello, hello. Mayday, mayday. Mayday, mayday. Okay. Thank you. Nice. Thank you. Thank you very much. Thank you. It's so funny. So that's the advantage when you're early.
Wait. Lagi. Oke. Uci mau? Menit?
Gimana ya?
Ah, bagus.
Oke. Now my
Lihat
turn.
Uci lagi. Ya, Uci lagi.
Pakai HP Uci.
Oh, iya.
Because my phone is better camera. Enggak, yang posisi cahaya itu. Mm-mm. Ntar.
Uci, ada di depan, Ci. Uci.
Ya? Oke.
Sini, sini.
zone. Thị lệ mà không vậy.
Second.
Hi.
The order of the speakers
Is Hassan?
So, we have Jyoti, then Pichuman, then Ria, then Justice Hassan
Huh?
for the first question. And then-
Mine is different, I think. Okay, yeah, sorry, yeah, Jyoti, Justice, yeah, that's good, that's good. So if they are sitting like,
So this is like when you're introducing them.
Yeah.
You're just introducing them, and then for the first question, so this is the first question, and Jyoti, Pichmon, Ria, and Justice Hassan are going to answer the first question.
yes, then the second
And then
question.
the second question will go to BJ and
And
Justice Hassan. Then the third question will go to Amarin, Pichuman, and Jyoti.
That's
Yeah.
perfect.
Yeah.
I'm the one who is not, I have it
Okay.
it with me. Okay.
Okay, good morning. So I will just. Good morning. Good morning, everyone. And welcome to day 2 of the 2024 United Nations People-Centered Justice Regional Conference, Achieving Just Societies, Inclusive Justice Pathways for People and the Planet. It's great to have everyone back for day 2, and we're going to start day 2 with the plenary session on strengthening environmental rule of law and the protection of environmental human rights defenders through people-centered justice. I'm delighted to invite to the stage the moderator for this session, is Patricia Kamiri Mabote, the director of the Law Division of the United Nations Environment Program. And if I could also invite up to the podium the panelists, Amarin, we have Jeti, Ria, Pichamon, and BJ. And we also have joining us online Justice Hassan. Okay, and so with that, I am now delighted to hand over the moderation of this session to Patricia. Over to you.
Good morning and welcome to this plenary session on strengthening environmental rule of law and protection of environmental human rights defenders through people-centered justice. I'd like to acknowledge the excellent context of this session within the 2024 UN People-Centered Justice Regional Conference, Achieving Just Societies, Inclusive Justice Pathways for People and the Planet. As Georgie has said, my name is Patricia Kamiri Mbote. I am the director of the Law Division of the UN Environment Program, and I'll moderate this session today. And I would like to welcome those joining us in person and those joining us online. Just to set the context, we gather here today at a critical moment for environmental rule of law. UNEP's 2024 Foresight Report, launched in July, shows that we are living in a moment of a polycrisis, and this was referred to yesterday, where global crises are synchronizing, accelerating, and amplifying. This report identifies key critical global shifts, one of which is persistent and widening inequalities, noting that inequalities of wealth and income will lead to ecological inequalities, with the wealthiest people contributing massively to climate change and environmental degradation, and the poorest people facing the most significant exposure. Indeed, the impacts of climate change and environmental degradation are not uniformly distributed. They have a devastatingly disproportionate impact on the world's most vulnerable and disadvantaged people, people who are socially, economically, culturally, politically, institutionally, or otherwise marginalized, are especially vulnerable. Women, indigenous communities, the rural and urban poor, small island nations, as well as both children, youth, and the elderly, face unique environmental and climate-related vulnerabilities, leaving them exposed to heightened risks. Environmental human rights defenders are increasingly being persecuted for upholding the protection of their human rights and of their environment. According to the latest report from Global Witness, only in 2023, 196 environmental defenders were murdered. Global Witness estimates that the total number of killings now stands at 2,106 murders since 2012. 766 of them are indigenous peoples, representing 36% of all killings of environmental defenders. These groups have been historically victims of environmental injustices, ranging from exclusion from environmental decision-making to deliberate attempts to cite toxic contamination in communities that have been marginalized. Key components of environmental rule of law, which we'll be focusing on in this panel, are strong laws, robust institutions, promotion of civic engagement, protection of rights, and access to justice. Without these elements, attempts to address climate change or environmental degradation may unintentionally impact the livelihoods of certain groups, by imposing greater financial strain on low-income households or perpetuating the situation of vulnerability. The environmental and climate crises are not just environmental or physical problems. They are also social economic problems, urging us to confront inequality on multiple fronts, between the rich and the poor nations, between wealthier and poorer populations within countries, between genders, races, ethnicities, and across generations. Today, we have a great panel with us to discuss these issues. We will hear from different perspectives that are critical to ensure inclusive, fair, and efficient environmental protection. They all have stellar biographies which are accessible online. So what I'll do is just give highlights of who they are. So, and I'm giving them not in the order that they'll come, but just letting you know the star-studded cast before you this morning. The first panelist is Justice Jawad Hassan, a judge of the Lahore High Court of Pakistan, who has been very involved in legislative and judicial reforms on child labor, domestic worker, and environmental rights. The second panelist, Amarin Saichan, is an environmental rights lawyer with 15-year experience working with Enlo Thai Foundation, or Enlo in short, to support local communities in Thailand in accessing environmental justice. We have Jyoti Mayo Anda, the co-founder and executive director of Environmental Legal Assistance Center, ILAC, a Filipino non-government organization committed to helping communities to uphold their human rights related to the environment. We have Ria Das, a human rights lawyer and a member of the Asia Pacific Youth Advisory Group on Environmental and Climate Justice, and also leading the IUCN Ali Career Environmental Law Specialist Group on Networks and Partnerships Project. We have Pichamon Yopantong, the chairperson of the Working Group on Business and Human Rights, an associate professor and head of research at the Center for Future Defense and National Security in Deakin University. We have William B.J. Schultz, a lawyer and member of the Environmental Legal Assistance Center, ILAC, and also previously worked with Earth Rights International. So we'll start with Jyoti, Pechamon, Ria, and Justice Hassan, who will answer the first question. What are the barriers for environmental rule of law that relate to strong legal frameworks, effective political, administrative, and judicial institutions, and access to information and access to justice? You have 5 minutes. We begin with Jyoti.
Thank you, Patricia. Mabuhay, as we say it in the Philippines. Good morning. It's a privilege to be here. The Philippines is noted for a lot of environmental laws, environmental justice laws, and when you name it, you probably have it. But one barrier is basically what I would characterize as rhetoric versus reality. It's not enough to have laws. It's very important that these laws are effectively implemented. So the challenge to us is basically governance. You have to make sure that the laws are actually implemented by institutions with clear mandates and also accountabilities. And this is the problem. The functionality of these institutions has always been a challenge for us. Example, we have the Indigenous Peoples' Rights Act, the one of its kind in Southeast Asia, probably, but the cases that we're handling at the moment, Indigenous peoples are being slapped with suits, and free and prior-informed consent processes have been marred by irregularities. It's also important to note that while we do have commitments, for example, the Kunming agreement, but we have protected areas being subjected to extractive activities like mining. Even our oceans, marine protected areas are also subjected to seabed mining, reclamation, and while we have some energy plants, coal is still a major issue. So there is a disparity. The laws provide for protecting our forests, our old-growth forests, but on the ground, you see a lot of forests being destroyed to pave the way for extractive activities. I've mentioned about a conducive legal and policy climate for us, because we built on this when we push for advocacy work and strategic litigation, but the gap there has always been the enforcement and implementation. Patricia mentioned the Global Witness Report, and it's important to highlight that the killings and the strategic lawsuit against public participation, is also a barrier. Right now, we're dealing with a slap suit of 10 million pesos against 25 community members in the beautiful province of Palawan, also in the north, 10 million pesos again against 2 champions opposing reclamation. And there are many more. And this actually, they send a chilling effect to the environmental and human rights offenders. And finally, I think there is still a contentious issue on the development paradigm in the Philippines. You push for sustainable development, but if you look at what's happening on the ground, you want to spur economic growth from COVID by allowing mining, and there's an influx of mining applications in Palawan, for instance. And while you do have the IPRA law and other social justice laws, the reality on the ground is there are problem areas. So I'll stop at that. Patricia, thank you.
Thanks, Jyoti. Pichamon, if you can pitch in.
Sure. No, thank you for that. And I can only really agree with what Gersi has said in terms of the shrinking civic space that we see in this region serving as a major barrier when it comes to ensuring that the environmental rule of law is being sustained as well as respected. I think it's also very much the case that what we see is an uneven and inconsistent development of jurisprudence on the environment across the region as well. We see, for example, in the Pacific, amongst Pacific island countries, despite the recognition that protecting the environment and upholding the environmental rule of law are critical to ensuring that the climate crisis, amongst other environmental challenges, are being addressed. We don't see a lot of environmental jurisprudence being developed in that part of the world. In addition to that, I would also say that this speaks very much to the lack of awareness when it comes to the international obligations that states, as well as other non-state actors like businesses, have in relation to protecting the environment, but also to ensuring people-centered justice. And as a member of the Working Group on Business and Human Rights, we of course work a lot with states as well as with businesses to highlight to them the importance of both mandatory and voluntary measures such as the UN Guiding Principles on Business and Human Rights, and how important it is for them to realize that their international human rights obligations and responsibilities very much encompass the requirement for them to also protect the natural environment in view of the human right to a clean, healthy, and sustainable environment. So I would say that even though we're seeing growing recognition that protecting human rights alongside the environment is extremely important for this region in order to ensure the realization of the Sustainable Development Goals and so forth. It is very much the case that the actual enforcement, as Gersi said, remains uneven at best, but it is also very much the case that when it comes to ensuring that jurists and other very relevant stakeholders are aware and have the channels available to them to push through enforcement at a local level, and in particular ensuring that actors like businesses are on the same page. That is another major barrier, which then has a cascading impact on the ability of affected rights holders to access information, access justice, and indeed access remedy. So I see all of this as very much intersecting barriers that invariably we can't just focus on addressing just one, we need to address all of them.
Thank you very much. We now hear from Ria.
Thank you, Patricia. Namaste. I'm Ria from India. And before I dive into the broader aspects of access to information and access to justice, I want you all to imagine a lush wetland teeming with life, supporting the livelihood of hundreds of families and local communities. And suddenly one day, this same wetland is labeled as a wasteland in official government documents. This is not a mistake, but perhaps a deliberate act embedded in a misleading environmental impact assessment, also known as the EIA, that is intended to pave the way for multinational cement plant to transform this ecologically diverse land into an industrial wasteland. To challenge this defective EIA, a group of grassroots defenders decide to approach the lower courts, then the higher courts, and when their efforts turn futile, they approach the Supreme Court. This is neither an imagination nor a story, but a case that I had the opportunity to work on and witness the resistance movement led by grassroots defenders in India. Fortunately, after years of legal struggle, the Supreme Court in this case revoked the environmental impact assessment, confirming that this EIA was defective and indeed misleading. So do we see the complex layers of barriers here? I will say yes. First, prolonged legal proceedings. The legal process itself in this case was arduous. The grassroots defenders had to travel all the way from district courts, then to the higher courts, and when their efforts turned futile, they had to approach the Supreme Court. So it was not only time-consuming, but also the resources of the communities that is limited, it drained the resources. Second, this case illustrates procedural lapses and lack of access to environmental information, that is flawed EIA in this case. Third, EIA proceeded in this case without meaningful community engagement and inputs, where they had no access to information about the project that was going on. So now, speaking more broadly about access to information and access to justice that these EHRDs face, access to information is often hindered by lack of environmental disclosures, by governments often deprioritizing the dissemination of critical environmental data. In India, however, right to information, also known as RTI, plays a critical role in generating vital environmental information, including the EIAs. However, in several cases that I have had the opportunity to work on, we have seen even RTI requests have failed to provide complete environmental information, prompting us to approach specialized RTI courts for seeking accountability and transparency from the governments and businesses. To add to another layer of complexity, language is yet another barrier. And particularly for a country like India that is so linguistically diverse, access to information and access to justice might often be inaccessible to grassroots defenders who might not be proficient in the official languages of the country. Moreover, for EHRDs seeking access to justice, the obstacles are even more profound. Judicial threats such as criminalization, arbitrary arrest, and criminalization under draconian laws such as the national security laws or anti-terrorism laws, and freezing of bank accounts often limits the ability to access justice. And as the previous speakers have spoken about, slap suits that's more prevalent in Southeast Asian countries. But also I would like to bring your focus to youth EHRDs and children EHRDs and the barriers that they face in accessing justice with regards to the limited resources they have and the legal standing that they might have. So therefore, there's an urgent need to adopt a people-centered approach to foster a more equitable legal landscape for all. And in this light, I would like to draw your attention to a recent decision by the Supreme Court of India to recognize the rights of vulnerable and marginalized communities against adverse impacts of climate change. Thank you.
Thank you, Ria. We'll now turn to Justice Hassan, who is online.
Good morning. The biggest barrier for the environmental rule of law is the recognition, non-recognition as an environmental right. As environmental human rights defenders, I've done a commendable job that I can share a good story for Pakistan that we have this 3 A's in the constitution because of the new amendment, the right to environment now recognized after the Supreme Court judgment just 10 days ago, right to healthy environment and sustainable environment. We have a right to information, 19A, and right to a fair trial. And the biggest, because Pakistan's was the only country in the world which didn't have the right to environment in the constitution, and there was no implementation of the environmental laws. But the Supreme Court of Pakistan in Sharia Wabda then held that rights to life under Article 9 means rights to a healthy environment in 94. After 30 years, the government realized to amend Article 9A, rights to environment. Once it comes down as a fundamental right, then the government then makes more efforts because every country has the laws. They have research-based laws. There has to be a will of the government to strictly enforce those laws. Just recently, a first case which I shared with you yesterday, and another good news from sharing from Pakistan is since we got this right to environment as a fundamental right 10 days ago in our constitution, I brought the case of 3 years old girl who came out and said, I'm living in the most polluted city of the world is Lahore, and my right for my future sustainable development is now under threat. And I had to develop a concept based on the Philippines judgments of Antonio Opasa, where the Supreme Court of Philippines held that doctrine of intergenerational right. Because if you read our constitution newly added right to sustainable environment, and sustainable is a word used in our law, which also means to meet the ends of future generation without compromising, that we are now trying to interpret these two articles for the intergenerational rights, that I want to live and I can't go to school, I can't go out to play in my own garden, I can't go out of my house. This is not what is the life I'm getting now? Who is responsible? We have a duty and obligation of the state to protect that right to me. That is what the whole concept is. The barrier is once the fundamental rights are recognized by the constitution and enforced and protected by the judiciary of the countries, because right under jurisprudence, the definition is right is an interest recognized and protected by the rule of legal justice under the rule of law. That is what the whole crux is, because this has been the whole debate when the civil and political rights came in the 50s, then economic and social rights came in 60s, then the environmental rights came in 70s after Stockholm Conference and Rio Conference. It took some time for human rights to accept the environmental rights into their jurisprudence. But now they are all intertwined. Right to climate justice, environmental justice are all linked with the human rights because it affects the right to property, right to food security, and all are interconnected. Thank you.
Thank you very much. And I'd like to ask you, Justice Hassan, what are some innovations and good practices that have enabled the progressive development of environmental rule of law and the implementation of laws?
Yep. Pakistan judiciary is always in the forefront, which I spoke at COP and won't speak in COP now. We are leading the world in 10 of the first time 10 things we've done. One is the commission-based kind of judgments we give. If a case comes to us, our Supreme Court intervened and brought a commission on environment with scientific data, like Shalazia case, which was the case of the right to a healthy environment, was based on the epidemiology study from Sweden. And that is, we make a commission And with the finding of the commission, we come to a kind of a jurisprudence to protect, because Pakistani courts are known in the world for 10 things. One, first country to recognize the soft law into a hard law. The precautionary principles of the Stockholm Conference, the dubio natura principles of the Rio Declaration, all these soft law instruments, when we bring it to the hard law in the Pakistani Supreme Court judgments, it becomes a law of the country. Second, and the most importantly, how we do it is a committee. Sometimes in some environmental matters, which I've done so far, that's called judicial legislation, that sometimes an issue comes to us and we need to find, rather than fighting with the litigant, because the most concept is the public interest litigation, when it brought to the courts, what we do, that commission is to look into a scientific data, and the committee is, you make a committee with the secretary and the relevant stakeholders of the government, with the relevant academics and relevant experts. Also, we do it, get from the IUCN and WWF and mostly organizations to sit down with us and make out a gap on an area which we can do. And sometimes we need, like example is the issue of food security, the wastage of food and the climate crisis coming on. A girl wrote an editorial in the newspaper, and I took up the case. And the right to food security is a very famous case of Minnesota. This has been taught now at the Harvard Law School, and they are now talking about the area where there was no law. The committee sat down and proposed a kind of a rule to have a food security into a right to food and right to food wastage. So we do this kind of innovations based on the committees and commissions, how to go to a better jurisprudence. And the jurisprudence which Pakistani courts are developing, as the Asghar Laghari case, the Shah's case, which was the right to the climate justice, a right to water justice. Now we are giving some cases on right to a climate finance, something which is very important, which we spoke at COP and going to be speaking, is the global North's commitment to the global South. The concept of how the basic charters from the Agenda 21 to Earth Summit to the Paris Agreement to UNFCCC, only on one condition, that Pakistani law, the environmental law, has a provision. This says that all the international environmental treaties, MEAs, are a schedule of our law. And the rule says the government will make rules and will implement those provisions. That's a very good kind of big new thinking which courts have also developed, that now once it's a part of the law, the mandatory obligation of a state under the Vienna Convention becomes an obligation of a country to implement those provisions, like for climate justice, for hazardous waste, for wildlife, and which our courts have done so far. Thank you.
Thank you very much, Justice Hassan. BJ, can you give us some of the innovations?
Sure, thank you, Patricia. And I think I'd like to focus on two sort of specific measures that I think will address some of the issues that were brought up earlier by Jyoti and Pichaman and others. One is, I think we're seeing sort of a growing trend around the world of the expansion of this doctrine of standing and other legal mechanisms to expand the ability of people and NGOs to actually step in and file litigation to enforce the law when the government is not doing so. So essentially authorizing them to serve as quote unquote private attorney generals. And the other one I'd like to focus on briefly is related to environmental impact assessment and strengthening the EIA system, which is often the first entry point for communities to get involved in decision-making processes that are going to impact their communities. So getting back to citizen suits, the idea is sort of based on an innovation that came from my home country, the United States, which is now more than 50 years old, so it's hard to call it an innovation at this point. But the point I want to make is that these citizen supervisions were originally specifically adopted with the idea that the government, even a well-resourced, well-funded government environmental agency, will not have the ability to enforce the environmental laws against all facilities. So the government, taking this into mind, specifically adopted provisions to allow communities and NGOs to come in and do so. And it's really been a big success. It's been a way to bring a lot of facilities into compliance with environmental laws and to act as a deterrent for would-be polluters. And building on that, I'd like to point to China as another example. After years and years of advocacy by NGOs in China, the government finally amended the environmental protection law in 2015, and it's hard to imagine that it's already been almost 10 years since that happened, but it was really a watershed moment in China that allowed NGOs to file litigation for environmental damages in the public interest as opposed to seeking private compensation. And following that, the Supreme People's Court of China issued a judicial interpretation of the law, which in many ways expanded the, this ability for NGOs to bring these suits, including clarifying that the courts can award the cost of litigation and attorney's fees to the plaintiff when the plaintiff wins the case, which was not in the original law. This was something that was clarified by the Supreme People's Court. And then another innovation from the Supreme People's Court that I think goes to the idea of strengthening the judiciary and strengthening their capacity, as well as access to information, is that the Supreme People's Court regularly publishes what they call guiding opinions on environmental cases. So they'll pick some highlight cases and publish those so that lower courts can learn, how the higher courts are addressing these issues and sort of develop the jurisprudence that way, and also to share the information with people so they can see how the courts are addressing these issues. And I know, especially in this region, in the Mekong region, that access to information, especially of judicial decisions, remains a big challenge. And staying in this region, I know the Philippines and Indonesia also have laws on their books which are intended to give NGOs the ability to file these types of citizen suits. I think we heard from Jyoti earlier, and I've heard from many colleagues in the Philippines and Indonesia that challenges remain. However, it's encouraging to see that governments are recognizing the value of allowing NGOs to supplement government enforcement power. Cambodia recently adopted a new Environment and Natural Resources Code, which includes a provision that, at least on its face, looks like it expands the standing doctrine in Cambodia. This law just came into effect last year, so that will be a very interesting space to watch how that develops over the next several years. And then turning quickly to EIA systems, one of the most common topics I think that comes up in conversations about EIA systems, at least in this region, is how to adopt measures to essentially strengthen the professionalization and, importantly, the independence of EIA consultants. I think there's often a perception that, whether rightly or wrongly, that EIA consultants are sort of lack a sort of independence from the project developer and what the project developer wants. And so in doing some research, we've seen a lot of really amazing examples from countries around the world that have very robust systems for professionalizing and maintaining a high standard of conduct for EIA consultants. Some in this region. I know Malaysia has a very strong system. In some other regions, Costa Rica is another example. But these systems for sort of ensuring that EI consultants have to follow a code of ethics in candor, and the information that they provide to environmental agencies can act as a very strong support system for communities that are getting involved in that process. And again, to refer, use Cambodia as an example, they, in the new code, they have adopted provisions that direct the Ministry of Environment to develop a registration scheme for EI consultants. So that also will be a pretty interesting space to watch over the coming months and years. And so I will leave it at that. Thank you.
Thank you very much. We go to the third question. Amarin, can you tell us how the role of environment human rights defenders can be strengthened and an enabling environment be put in place to support their role in advancing people-centered justice?
Thank you, Patricia. Good morning, everyone. I'm Amarin from ELLA. I'd like to share my experience from working with local community in Thailand in exercising environmental rights, which I think at some point it will also reflect the situation facing by our friends in Mekong or neighbor countries. First, I have three key elements that I would like to highlight in strengthening the role of EHRD. First, the safety environment of for the environmental human rights defenders in Thailand. The EHRD are facing both the physical and judicial harassment. Although the physical one may be reducing, but actually we can see that it's keep happening. It's still happening in the local area, the far community, which maybe not acknowledged by the government or by the central media, but. There is a case of the government official who visit the community leader or the EHRD at their home for those who are standing to protect their right. And there's a lot of slap case, like the criminal defamation that keep happening against these EHRD. In our recent case, it brought by the local authority against the community representative who just like making comments on the Facebook page. So these kind of slap case are using as for the negotiation for negotiation or making people to stop protesting against the development project, the waste-to-energy project, and there's still no effective mechanism to prevent this kind of slap lawsuit. There's no real anti-slap law in Thailand, so that's one thing. And the other thing is we still lack of the effective judicial mechanism like the environmental court or environmental case procedural law. Although we have the division in both the civil court and the administrative court, but in reality the role of the judge in making setting the precedent to protect or making the environmental rights stronger, it's not really happen because there's no specific procedure to provide the court with the special mechanism. Like, for example, there's some in one case about the mining. It took almost 10 years to reach the final decision, and the court did not really realize that it's a need to have like a temporary injunction order to prevent the mountain from being exploded during the case being considered in the court. So that's reflect that we need to have the law or the specialized court on the environmental case, or at least the procedural law to provide them with this mechanism, which if we have this judicial mechanism, it will allow people or the EHRD to easily or make it easier for people to bring the case to the court and having the better decision given by the court. And lastly, it's very important to have the right to healthy environment being recognized clearly or straightforward in the constitution. In Thailand, we almost there. I mean, in the past 20 years, since 1997 and the 2007 Constitution, we almost have the right to healthy environment being recognized. But after the military coup in 2014, that Constitution has been demolished, and right now in our constitution, it's just like the soft recognition of the procedural environmental rights, but not the substantive right of the right to healthy environment. It's very important because this will be the legal ground for both for the court in applying these constitutional rights, in interpreting the law in their case, or in applying. It will be the channel for the court to applying the environmental principle, or even the international environmental law into the case. Without this recognition of environmental rights in the Constitution, it make people very difficult in, and also as a lawyer, it's also difficult in proposing to the court how the case or how such a development project is being is affecting the people's rights, and we can see that the court also like a lack of the legal ground to make a good decision to protect the environmental human rights defender, not both in the case that we file like against a development project or in the SLAP case. So I think if we have the strong recognition in the Constitution, it will also reflect in the development or the improvement in the environmental law, like a law on the access to environmental information, or the EIA law. Whereas if there is still the loophole in the law, but if we have these rights recognized, it can fulfill that loophole. Thank you.
Thank you very much. Amarin, Pishamon, can we hear your views as well on environment, human rights defenders?
Sure, no, absolutely. I mean, I think, Patricia, everyone here really, you've all been working on these issues for so very long, and I'm sure the same can be said of so many people in this room. And I feel like in many respects, we're talking about the same challenges, the same barriers, and you know, what is needed when it comes to strengthening the role of environmental human rights defenders is obviously addressing the root causes of the challenges that they're facing. It's about focusing not just on, in a way, the mitigation or providing justice and remedies, it's very much also about the prevention piece, right? We want these issues to not be issues in the first place so that environmental human rights defenders, the communities that are impacted, whether it be by large-scale development schemes, mining operations, or those types of very environmentally adverse projects, that the negative human rights and environmental harms that come to them are prevented. And I feel like we can all agree on these issues, but the question is, where are the bottlenecks, and who's supposed to be in this room that's not here? Who are the agents of change that we need to be speaking with beyond these doors in order to get many of these barriers deconstructed and for us to really find a way forward? And I guess there's probably a strategic reason as well for why I am seated between BJ and Justice Hassan. I feel like it's Justice Hassan we're here. Following on the positive developments that both of you had enumerated earlier, it's of course important for us to bear in mind that there is progress. It's not just we're standing still and nothing's happening. And I do fully acknowledge that. But I do also note with frustration, the frustration that EHRDs face on the ground. And that in many respects, it's not just about enacting new laws, it's actually about enforcing existing ones and ensuring that the basis for enforcement is continually improved upon in this region, and that enforcement happens along the lines of the ground realities, the lived experiences of those who are being impacted by development projects and the like. And so for me, in terms of how can the role of EHRDs be strengthened, it starts with acknowledgement, especially by government, and indeed for the working group, it's also about businesses acknowledging the pivotal role that environmental human rights defenders play when it comes to preventing the adverse human rights and environmental impacts of business operations, but equally when it comes to ensuring that there is access to justice and access to remedy, whether it be through state-based judicial mechanisms, non-state-based judicial mechanisms, including operational level grievance mechanisms, for instance. I would also like to emphasize the recurring issue that's been addressed already by my colleagues here on this session, which is strategic litigation against public participation, or SLAPs. I've said before that I view SLAPs as a very cowardly tool that are used by businesses in particular to harass environmental human rights defenders and prevent them from doing the legitimate work that they do in contributing to society and to protecting the environment. But the reality, certainly for Southeast Asia, is that these SLAPs continue to happen. And judicial mechanisms that we see in this region are still ill-equipped, relatively speaking, to recognize what a SLAP is before it actually goes through the court processes. And this creates a lot of frustration, but also a lot of heartache and a drain on resources, especially for civil society organizations, but human rights defenders, environmental human rights defenders themselves, when they have to contend with such litigation. And so for me, it is very much about putting in place necessary legislation to prevent SLAPs. It's about putting in place capacity development opportunities for members of the judiciary so that they can better recognize a SLAP case and not prosecute it further. And it is also, to echo what BJ was saying, to have specialized courts. And to have people with that specialization in human rights and environmental rights and so forth being part of the judiciary as well. And then the very final point I wanted to add in my remaining 20 seconds or so is that I think when we think about EHRDs, we have to bear in mind that they, of course, are not a homogeneous group. Environmental human rights defenders are made up of very brave women, men, gender diverse individuals, persons with disabilities, and indeed, as was mentioned earlier, youths and indigenous peoples. And their experiences as environmental human rights defenders will, as a result, vary. And therefore, the needs that they have, the requirements that need to be met in order for them as individuals to be able to access information, access justice, access effective remedies, will need to vary as well. And so for me, this is a bigger, deeper question about how can we enhance not just the scalability of existing judicial mechanisms for those who stand to be most affected. It is equally about enhancing the quality of the access to information, justice, and so forth for these individuals, in a way that really recognizes their intersectional experiences, the fact that the challenges faced by Indigenous peoples will be very different, especially if you consider the ongoing context of the so-called just energy transition. We see how the range of challenges that Indigenous peoples face in this region are growing by the day. And it also stems in large part from the fact that they are not recognized as Indigenous, and they are still referred to as ethnic minorities in many parts of Southeast Asia and the Pacific and beyond. So for me, it starts with that recognition. It starts with acknowledging that we do have a lot of problems here, problems that have not really changed that much, I would argue, from 2-3 decades ago. But nonetheless, with the positive developments that we see, I think there is an opportunity for us now to really come together in light of the just transition to ensure that access to information, access to justice is one that is open to all and not just a few. Thank you.
Thank you very much. We've heard from all the panelists, and we would like to now give an opportunity for the audience to ask any questions they may have. We have a question there. Yes.
Thank you. I'm Freddy Busro from Indonesia. And as you mentioned about the freedom of the expression, the freedom of the speech, that's a very big issue in several countries maybe. And I'm wondering in digital era right now, so sometimes what we have to expression, the freedom of expression, is censored by the government, and sometimes with the digital platform, and missing the comment. So I want to ask some questions. How does the censorship on digital platform affect the public discourses, and what safeguards are needed to protect online freedom of expression? Thank you.
We have another question so that we address a number of them. Looks like the questions are in this space. Yeah, next. And please identify yourself.
Thank you so much. So I'm Tek Tamat. I work with UNDP Country Office Nepal as a portfolio manager. I look after governance and rule of law. I have a question in regard to one of these statements, made by the judge, I would say, of Philippines. And this is about the execution and the implementation of policies, normative frameworks, so far developed in regard to environmental rights and sustainable development. That's a very relevant one, I would say, because in our, kind of experience, we have numbers of judicial pronouncements on environmental protection. Likewise, constitutionally, the sustainable development has been recognized as a fundamental right. On, like business human rights perspective, we have plan of action in place, and there are numbers of provisions in regard to human rights due diligence. However, the implementation part is not much encouraging. So what would you suggest, based on your experience? It should not be generic, rather, like more specific prescription, so that we can, at least kind of move forward and coordinate, collaborate with concerned stakeholders to, set the foundation for the implementation. Thank you.
Thank you for your question. There's one here.
Thank you very much. I am Justice Nandi Indrawati from the Supreme Court of Indonesia. I just want to know for all panelists, in your country, slap attack to the court, to the environmental defenders or victims, in which matters only in civil cases or in criminal cases? Because in Indonesia, both in civil and also criminal, usually corporate attack to the victim or environment defenders by through civil cases and criminal cases. Thank you.
Am I missing any hand? I see none, so I'm going to give the panelists an opportunity to answer. We'll start with you, Jyoti, because there was a specific question to you.
Thank you for that question. Actually, we need to build on the gains that the Philippines has. Relatively progressive constitution, replete with human rights and social justice provisions. We do have a rules of procedure for environmental cases where SLAP suits, citizen suits, and special writs like writ of kalikasan and writ of continuum mandamus are also provided. But the gap, as I said, rhetoric versus reality is basically what we need to address. And that would mean sustaining efforts on empowerment, legal empowerment, because many of our citizens are still not aware of the rules of procedure for environmental cases. The Supreme Court is revisiting the rules, and they want to improve provisions on SLAP. How do we enhance efforts to address SLAP, both civil and criminal? So we have had cases of criminal and civil cases, justice, involving environmental and human rights defenders all over the country. And we are proud to say that in one cyber libel case against a woman environmental defender, we had her acquitted with a colleague. So it's a continuing struggle. Second, I'd also like to say that we need to engage with government. Champions in government are also subjected to SLAP, like a vice mayor, a mayor, and officials who have supported local indigenous and farmer communities and fisherfolk have also been sued. And therefore, we need to continue that engagement. The advocacy efforts should also be done, I would say. How do we build on the National Inquiry on Climate Change, which Commissioner Cadiz talked about? That was a civil society initiative led by Greenpeace and other NGOs. How do we take it an extra mile? So, to me, we have some gains, but we need to be more innovative, creative, and resourceful on how to expand this. Lastly, we do have a law on Philippine ecosystems and natural capital accounting, where the rights of nature was recognized for the first time. But the question is implementing that with implementing rules. So there are gains, I would like to summarize, that we have, but we need to build on those gains and sustain efforts on empowerment, awareness building, maximizing the role of the youth, indigenous peoples, women, and also pushing our advocacy efforts, plus engaging the judiciary. Not only judiciary, but executive agencies, both administrative and judicial remedies are being pursued, and we need to sustain that. Thank you.
Thank you. Ria, would you like to comment on the question on censorship and the impacts in the digital era?
Thank you. I think as far as censorship is concerned, we do have a fundamental right on freedom of speech and expression, but also speaking about digital rights, India does not yet have a stringent or a strong policy on digital rights. So that often hinders the rights of EHRDs on what they speak about or what they post on social medias. So they have to be quite mindful of before they post, they have to be quite mindful, because then as a question that Justice from Indonesia asked, that what are the threats that the EHRDs face? Is it only criminal or civil as well? So we don't have SLAP suits in particular, that's more prevalent in Indonesia, but for a country like India, we do have judicial threats such as criminalization under draconian laws such as anti-terrorism or laws such as not only anti-terrorism, but laws of national security, and civil threats such as illegal demolition of your properties. So I think I would like to answer that.
Thank you. BJ?
Just briefly on that question, I'm not sure I can answer specifically about online censorship, but I think with regards to EHRDs and the discussion we're having around SLAPs is one of the things you see, especially in this region, is just simply the laws that are used to prosecute these individuals often are really overly broad and vague and can sort of be interpreted in you know, any way that someone wants to that's pursuing that prosecution. So I think one thing that could be done is reviewing those laws and perhaps sort of either getting rid of them, which would be ideal, but really narrowing the scope and being, you know, specific about what actions, you know, could make someone subject to those laws. And you know, for example, in Thailand, I know, you know, just the act of being, you know, of a private company filing a complaint with the police for criminal defamation, and someone, you know, getting a call or a knock on the door from the police notifying them that they're under investigation can be, just that can be enough to you know, have a chilling effect and cause that person to, you know, bow out. And so I think some of those laws, some of those very overly broad and vague laws that are used to criminalize expression need to be looked at.
Thank you. Justice Hassan, do you have any wisdom to share on these issues?
Yep. I think I'll answer the first question on the right to information. As I was told that since we transformed Pakistani laws were very weak, as you know, countries in the Central Europe and countries where laws are strict and European laws are strict, they need less burden on the judiciary. In India, Pakistan, in South Asia, the judiciary is always led, and I must say that we, as a 22 years as an environmental human rights defender, we were trying to convince the government to add these fundamental rights. Once they are recognized as rights, then the government and the other authorities and the citizens have a right to approach the higher forum in the public interest litigation, like in American civil action case or whatever. Right to information was also included in our constitution as a fundamental right to have access to public information of public record. As that will has also brought a good jurisprudence that some environmental defenders trying to stop a project and they were not getting the information as per the EPA, and they got to High Court to ask for the public importance information. Like the Three Gorges Dam in China was stopped because funding was stopped because of some multilateral banks. These are the very important issue which are all intertwined together with the article of the right to information or public record on the environmental matters, which includes the entire, not the country, the whole universe also as a world one unit. Two, right to the environment, which should be included in every constitution now, because this is the, if the rights are there, then courts and the EPA and the public are strengthened. Their confidence, because they don't come to court, they come to get their right from the courts. And there's a duty of the court because it's an obligation, as now the new theme coming up, the obligation of earth on earth by us. And the third and the most importantly is right to a fair trial and due process. The answer which somebody asked a question that now because these rights are all enshrined from the United Nations Declaration of Human Rights 1948 and brought into the civil and political rights, economic rights of the covenants of 66, and then also some international treaties, some draft treaties, some soft law and hard law. On this particular field, on environmental and human rights now, there is so much public international law. Some countries have signed, some countries have ratified, some countries have incorporated, and the world I'll divide into not environment as north or south. I divide into a civil law countries or a common law countries. I divide the world into the world which will now be looking into what kind of international law they will be implying to, whether they are like Germany or France, a monistic country, or like the rest of the world, a dualistic country. Now we have to now think and bespoke some kind of rules to have the entire world to connect it together. And I'm very grateful to all of you to provide this opportunity to share our story of a good news from Pakistan, that finally the government realized after 52 years of the constitution to bring a right to environment. As in the constitution which we were debating, there were judgments passed by us from time to time, and now we all feel so good that this is a story, because we were the only left out country out of 194 states in the world for not having a right to environment. Even our neighbor Afghanistan has a right to environment. India got in 1986 in the constitution. We never had that right because we were only depending on the Supreme Court judgment that right to life means right to healthy environment. Thank you.
Thank you very much. Amarin, do you have views on this?
Yeah, just to add on the censorship or the restriction of freedom of expression and association. In Thailand, apart from the slap case, mainly the slap case, they use the criminal defamation and also the guilty on the Computer Crime Act, yeah, and which is used commonly on the posting, like a posting or commenting on social media or Facebook. And right now, many environmental groups or community groups, they have their own channel to communicate with the public, and it's quite risk that there's a law that being interpreted quite broadly in preventing them from exercising the freedom of expression. And other laws from the criminal defamation, there's also the Public Assembly Act, which also affect the exercise of freedom of assembly of the people, because many group, many community, they have to voice their concern, and they have to gathering together like at the house of the parliament or the cabinet house, and they have to face with many restriction or regulation on how they can demonstrate or organizing the protest, and many cases they have to face with criminal charges. And also there's an attempt from the government to push for the law on the operation of the non-profit organization, or the law on association and foundation, which has include some broad authority for the government to control the not only the procedure in or the registration process, but also in control into the contents or the activity of such CSO in operating their organization. The law is just the draft, but we have seen this attempt from the government for several times, and if it can pass, it will for sure affect the civic space in doing the human rights work. Thank you.
Thank you. Pichaman?
Sure, thank you. I suppose for me, it's just to go off what Kun Amarin was saying. I won't say too much about the Thai case, because I think Kun Amarin can give you a better sense of the trends when it comes to slaps and how they're used here. I would say, in fact, in Australia, so looking farther afield to the Pacific or Oceania region, I think we've been seeing, they don't usually get called slaps, but we have been seeing an emerging, if not growing, trend amongst private sector actors of using defamation law, which is civil in Australia, as a means to silence or attempt to silence civil society, environmental human rights defenders, especially in cases, at least as we've seen as a working group, in relation to the oil and gas industry. So we have been seeing that, and I guess it's, it just speaks to the fact that this is becoming a tool that's being used elsewhere as well, beyond Southeast Asia, and that's very concerning. On the question about freedom of expression and speech, I suppose I wanted just to say that I mentioned earlier how we should be focused not just on enacting new laws, but really on enforcing existing ones. And I think what Gersi and Ria were saying resonates in that we should also be thinking about dismantling existing laws that just simply do not work and that in fact conflict with the protection of people's human rights. And the ability on the part of the state, the private sector, and indeed civil society to uphold the environmental rule of law as well. And, you know, in relation to the Philippines, certainly the anti-terror law is one that we as a working group have received so many complaints about from civil society, from environmental human rights defenders who have been red tagged and who have been persecuted and harassed under the guise of enforcement of this specific law. And so addressing that issue is also very pivotal in this instance and in relation to protecting the right to freedom of expression and freedom of speech. I would also say that just on the question about enforcement, I note how you said that you wanted concrete examples of where enforcement can be improved and how that can happen. And I suppose looking outside of the kind of the judicial context, I think we as a working group have seen how, you know, when businesses come together, especially with civil society in partnership, in order to put in place, let's say, you know, an operational level grievance mechanism, that can certainly work towards non-state-based, you know, enforcement of the law. We've also seen how, in relation to financiers and investors, someone was saying that earlier, you know, they can also play a very important role as well in driving businesses in particular to do better when it comes to upholding their responsibilities under international human rights and environmental laws and standards. And we have certainly seen how an investor divests from a project, not saying that that's always the best decision, but we have seen when they've decided to divest from a specifically, from an especially problematic project, that can help as well to really reinforce the importance on the part of the private sector in upholding and fulfilling their responsibility to respect human rights and the environment in that way. But just on one final point, I wanted to say, we've been talking, I think, about the environmental rule of law and holding that in a national context. I think it's also important for us to think about it in a regional context and to think about the challenges that remain when it comes to enforcing environmental law at a transnational or in an extraterritorial setting. And this is where we still see a lot of gaps, but that's not to say that there hasn't been progress. And I think here we need to focus a little bit more on understanding in particular how the right to accessing information in that transnational context is very important because, again, we as a working group have received complaints, concerns from environmental human rights defenders and other stakeholders about issues like, you know, the release of treated water from the Fukushima nuclear plant in the Japanese case, and how that could potentially impact the right to a clean, healthy, and sustainable environment for other peoples in neighboring countries. And I think sharing information, being transparent is very important here. How we accomplish that at a regional scale is one of the issues I think we need to delve into more.
Our time is almost coming up, so I'd like to just give the panelists each a minute to sum up what they would want people to live with. I'll begin with Justice Hassan. Justice Hassan, just give us your final word of wisdom.
It's me, yeah. Are you asking me?
I'm asking you
Hello?
to give us a final word of wisdom.
Can you hear me?
Okay, I think we go to the other panelists. We'll start with Ria this time, if you can give us a final word of wisdom.
Yeah. Final word of wisdom.
Yes, please, Justice Hassan.
Yes.
A final word of wisdom.
Yep. Can you hear me?
Yes, we can.
Yep. Final word. Yep. My final word of wisdom based on this work is that
Looks like we're having internet issues. So, Ria, if you can proceed.
My final words of wisdom would be that even though there are obstacles that we discussed, but we also have learned the best practices from all the panelists here. And I think my final key takeaways would be that we need effective, impartial, and independent My final key takeaway that we need impartial, effective, and efficient investigation mechanism and specialized courts that could take away the burden from the courts that are already flooded with a lot of cases. And I think youth EHRDs and children EHRDs also need to be given a space. As Pichamon mentioned, that we need to look who are the people that are here and who are all other EHRDs that need to be present here so that we have all the voices at the table. Thank you.
Thank you. Amarin?
Okay. I think in the attempt to make the people-centered justice really happen, I think we have to make people or the EHRD really believe that they have or believe in their rights of the healthy environment, and that could becoming real through the recognition in the Constitution. People are doing their hard work in protecting their environmental rights, but they may not realize that, it's the human rights, it's one of the human rights. So our role is how to recognize their roles and also recognize these rights in the strong way, in the Constitution. Thank you.
Thank you. Yechi?
Yes, thank you. I mentioned about sustaining the gains, and to me, we need to really sustain the empowerment processes, the awareness building, broadening the constituency, to me, because we do have good laws, relatively good and progressive laws in the Philippines, the rules of procedure, strategic litigation should still continue to be pursued, and even with the anti-terror law, we have to continue the advocacy. We really need to build on the gains by several groups, not only here, but also outside of this conference, and we be inspired by the good practices, and we should not get, although we can rest, but to me, when we push for eternal vigilance, patience and perseverance, pardon me for raising this, are really important values, because in this work, many of us have been here for like more than 20 years, more than 30 years, but the challenges are enormous. Thank you very much. Mabuhay.
Thank you. BJ?
Yeah.
Yes, thank you, Patricia. I think the one final thought I'll leave with is, a lot of this conversation has been centered around the idea of enforcement, and as Jyoti and others have been saying, that the laws are only worth as their value is in how much they are actually enforced and implemented. If they look good on paper but they're not enforced, then they're really not worth much. So one thing I've found in a lot of these conversations is that when it comes to talking about enforcement, the government position is often that, oh, this is the government's job. This is our area, and we don't want anyone else to come in and infringe on this. But I think it's important to sort of frame the conversation and sell the idea that empowering communities and NGOs to bring cases to the court to enforce the laws is really a supplement to government enforcement power. It's not a replacement. It's not an infringement on government enforcement power. It's a supplement to it. And this is something that's a very strong tool and kind of a simple fix that can be adopted through legal mechanisms that can really go a long way towards empowering communities and to meeting government goals for sustainable development and environmental protection. Thank you.
Pichamon?
I feel like at this type of event, someone somewhere has to say justice delayed is justice denied. I'm not sure if anyone has said that yet, but if they haven't, then I'm saying it right now. But for me, upholding the environmental rule of law is important for the reason that we should not delay justice, because that would be tantamount to the denial of justice for all. I would say the environmental rule of law is also about enhancing predictability. It's about enhancing opportunities for dialogue, transparency, accountability, and it's also about embedding ownership of this structure of the justice that we want to see manifest, materialize in our societies. And so for me, I wanted to really end on a note of thanking UNEP for putting together this session, because I do note that it's perhaps the only session at this two-day event where environmental human rights defenders and the important role that they play is explicitly acknowledged and mentioned in the session. And to go back to what both Gertie, Ria, and BJ have all said, it's very important that we ensure that there is the inclusion of those diverse voices, and to ensure that at the end of the day, judicial processes that we see in place are actually serving the interests of the people so that their fundamental human rights as well as the environment are protected.
Thank you. Do we have Justice Hassan? Justice Hassan, your final word.
Yeah, fine. My final piece, advice or suggestion would be that we should learn now from the international good principles already made for the last 50 years, the precautionary principles like from Stockholm principles and Rio de principles, and so many soft law good principles which have been now brought into by the law research articles, by the jurists, and some of the judgments in the world, and we can learn some kind of, and also we can use them in our country. My example would that when I was doing this case last week on the right to a 3-year-old girl talking about her future for the city, the most polluted city in the world, Lahore, and I had the hurdle that whether a 3-year-old girl, Amal Sukhera, can come to my court, because Constitution uses the word person. The Constitution, which is not a child, Constitution uses the word for fundamental rights, an individual, a citizen, and there are so many words used, but the constitutional judicial view is for party. And I had to then only way to look into the Supreme Court of Philippines judgment to bring it to my jurisdiction to say yes, for somebody to come to my court by the concept which was driven by the UN, by the UN conventions, by some kind of principles, some soft laws brought into the Supreme Court of Philippines in Tonio Opasa case, where the concept that this is our future generation and a generation yet to be born. That is a principle and advice that I always give you whenever you have any issue in anywhere in the world. There's a Judges Global Institute, there's a platform like UNEP has the good library where all the judgments are there. And even a small issue when I had to pass a judgment on adaptation for the mitigation measures in Pakistan for climate justice, I had to look into, and only way we can look into the mandatory obligation by the state and also the soft law, which is now a part of this. And my advice to you, always learn, now it's time for action. We have, we're all quiet in Stockholm 50 years ago. We did speak at the Rio, where the largest Congress happened. Then the world came to the Rio 20 plus. Now the world is now coming to taking action, because if you don't take action, I am suffering from the worst in the world of the worst pollution in Lahore. And that is all the result which we are seeing. Thank you.
Thank you very much. I think we end the panel on a point of hope the glass is not half empty, it is half full. There are pathways to people-centered justice, and we see movement not just from top to bottom. We learn from international norms, but we can also see, like, the right to a healthy environment. Many countries had this in their national constitutions and laws, and then the international community took it up. We also see little things like, or seemingly little things like the environment impact assessment,
तो सुना
and
था
we
अभी
begin to look at it from
तो
a
छोड़
new
दो सुन के
lens, where
anyways
it
what
is
about
very important and actually can lead to big differences. Then there are interlinkages, the laws on information, and the right to a healthy environment, or laws on environment. There is intersectionality. So in essence, since rights do not go to people, people have to look for rights, it is incumbent upon all of us to work towards people-centered justice by ensuring that all have access to justice. I'd like to thank my panelists for a very enjoyable panel, and also for sharing, and also the audience for having engaged the panelists, and then bring this to a close, and thank you all.
Thank you very much. Thank you, Patricia, for the excellent moderation of that panel. So it's now the break time. There is a break until 10:45, so a little over 15 minutes. And after the break, there are the 3 concurrent sessions. There's a session here, and then there are 2 other sessions in the other 2 meeting rooms downstairs. I think meeting room G and meeting room A. So please choose one of the 3 concurrent sessions after the break. It's starting at 10:45.
I'm not sure it's not okay. It should be. Maybe the speaker can. Dear guests, just to add what Georgina said, we have about a conversation in meeting room A after lunchtime today. It should be a great opportunity for you to join us for interactive discussions with our lead agencies and partners. I really look forward for you to join this session. Thank you so much.
Okay, so Hello, everybody. We'll be starting the session in a moment. We're just rounding people up, but it's going to be really interactive, this session. So please move nice to the front, and yeah, we'll be starting in a moment. Welcome, people who are just joining. Please come and stay at the front. We want it to be a nice and cozy session together, since this is a concurrent one. So, yep, we'll be starting very, very soon.
Hello, colleagues. So this room is for the session on justice innovation, and the data session will be in meeting room A, which is downstairs, and another session led by IDLO on customary justice will be in meeting room G, downstairs as well.
Fantastic. And folks, please feel free to take the seats at the front as well. Let's have a nice cozy session together. We'll be starting our Justice Innovation session in just a few moments. Okay, fantastic. So I think we still have a few people joining, but I think we can get the show on the road. So welcome, ladies and gentlemen, to the session Justice Reimagined, Fostering an Ecosystem for People-Centered Innovation. So my name's Callum Mackenzie. I'm the co-founder and managing director at Yunus Thailand Foundation, and I'll be the moderator for this session today. And really appreciate you joining us. We hope this is going to be an interactive session. So please get ready with your questions, with your discussion points. We're going to have a really big chunk of time at the end for an engaging discussion. And what we're going to be looking at today is the topic of how we can catalyze an innovation ecosystem for people-centered justice. So this topic has been something that we've been looking into for the last 6 months. And I'd like to first welcome on stage my colleague, Jonathan Brenners, who's going to be presenting a white paper. I'll introduce John in a moment, but we'll present this white paper that we've been working with many different stakeholders throughout Southeast Asia on. And followed that, we're going to have some leading voices from the justice innovation paradigm coming on stage and sharing in an interactive panel discussion, followed by the Q&A. So if this sounds good to everybody, I think we can get the show on the road. So, Jonathan, John is the Director of Programs at UNIS Thailand, with a particular focus on social innovation and social business approaches. He brings over a decade of international experience managing research, innovation, and capacity development programs, both in Thailand and throughout Asia, and particularly in the areas of inclusive development, social entrepreneurship, and climate action. He's also a co-founder of a NGO based in Portugal as well, the Sustainable Energy Youth Network, holds a master's degree from the University of Central Europe, and also a bachelor's from the University of South in Tennessee. So, Jonathan, it'd be fantastic if you can join us and share a little bit more about our work to catalyse an innovation ecosystem for people-centred justice. Thanks so much.
Thank you, Callum, for the introduction, and hello, everybody. Good morning, and thank you for choosing to join this session. It's my honor and my pleasure. For the past few months, we've been working to reach out to colleagues from around the region to invite points of view on this idea of what we can do to catalyze an innovation ecosystem around the topics that this conference is looking to dive into. And so I'll do my best to summarize the white paper, but on the screen you see a QR code where you can scan to get a digital version of the paper. And we also have a few copies in the TIJ stand in the exhibition space. And really looking into this idea of justice, innovation, and an innovation ecosystem, we really see this idea of an ecosystem as a set of interactions between different actors, players, and the types of relationships that come up in creating innovative ideas and interventions trying to drive people-centered solutions. And so I thought I would start just by sharing this vision, theory of change set by the Hague Institute for Innovation of Law, where they identify both innovation as a key approach to drive new solutions with putting people at the center, and on the other side, ecosystems as one of many leverage points that really can try to drive new ways of running activities. The Hill's work has very much also driven and identifying different examples of what they call game-changing solutions that are really trying to drive examples of innovation in different spaces. And so with that in mind, our work has really tried to consider 3 points. One, what are some of the elements and functionalities of the ecosystem, and what are some of the opportunities and challenges to drive innovation in this space? On the other, we've been trying to explore how can regional innovation relationships be driven for people-centered approaches in this space. And lastly, how can we mobilize actors and individuals in the space to take ownership and drive activities in a collective sense. And so here we know that within the space of justice innovation, there are examples that lie in the criminal system, as well in the civil system, and we heard yesterday in the opening session other ways to categorize the types of activities that can be taken on in terms of categories of themes of interventions. A lot of our focus has been in collaboration with the Thailand Institute of Justice, so some of the examples that we might drive into have more of a focus on the criminal system, but just a point to emphasize that the opportunities for innovation are quite broad in scope. And so what we did for the past few months is really reach out to as much as we can stakeholders from around Southeast Asia, innovation experts, and international development workers to gather points of view about what have been some of the experiences from across the region in focusing on people-centered approaches on the one hand, and also on working collaboratively to pilot or identify innovative solutions On the other hand, we also distributed an online survey where we gathered around 12, so rather a small number of insights, but very important from a wide range of types of organizations across government, private sector, civil society, academia, and so on. And we managed to schedule about 44 interviews with key informants from across the region to dive deep into some of these ideas. And you'll see in the graph as well the distribution of where the folks that we gathered these insights are geographically in terms of where they intervene. And so with this in mind, also along with the literature reviews that we conducted, again in collaboration with TIJ, the National Institute for Development Administration, and the Yunus Thailand Foundation, we began to explore then what are some of these patterns that ecosystems beyond just in this space share. And so here is just a brief summary of some of these points that we think an innovation ecosystem will need to try to incentivize and cultivate. On the start, looking into how we can cultivate market demand for these people-centered justice solutions. But also looking at densifying the number of individuals that are working in this space, how frequent are the interactions between these individuals, and how diverse is the network of individuals that are trying to think creatively around these issues. And with that in mind, then, a very important point is how we can cultivate a culture that prioritizes thinking outside the box and really tries to invite new points of view in designing these novel interventions that we hope can be integrated at large once they are proven. And so in that journey, we really see this role of bringing in support organizations and individuals that can help those innovators along the process in having access to co-working spaces, platforms for communication, opportunities to connect with other players, and of course, the other key point is access to finance to support both the early stages of innovation and the later stages of integrating those into the justice systems. And so with that in mind, of course, then there is this need to cultivate policies that really prioritize these points and create an enabling environment for leaders within institutions to be able to have the freedom to drive some of these ideas. And so with that in mind, the Thailand Institute of Justice has been very much looking into ways to try to make sense of the types of roles that are played within this idea of an ecosystem. And on the other hand, we try to think about what are the different stages of the design thinking process that are necessitating these roles to intervene. And at what level are individuals or organizations being committed to support innovative thinking. So this can be more of an individual level where a person can really take on this idea, but it can trickle down into a network level approach, which is what we are hoping to build toward. And so with this in mind, this slide tries to share a little bit of these ideas, or with, on the one side, having innovators kind of as the ones that are really driving this process, but very much doing so by gathering points of view of those who are working on the ground with the justice seekers. And we call those the issue champions that have more direct experience working with the stakeholders that are seeking access to justice, as well as the need to cultivate researchers and data to make sure that these ideas come informed by evidence, as well as also being able to monitor the results and the implementation of some of these solutions. And so the role of researchers within this ecosystem is very important. Lastly, there is this important role of course, financing and mobilizing creative ways to take on pilots programs into later stages that can be scaled up and integrated into the system, which brings me to the last point, which is this role of what we called here deployers, which are players that are very much trying to identify the leverage points to integrate proven solutions into the justice systems at scale. And so with that in mind, I'll begin to just make some reflections on some of the insights that we gathered from this process over the past few months. And kind of a big conclusion that really came is this sense that the landscape of stakeholders in the region contributing to innovation is very diverse, and also that the justice systems that we're working with in the region are also at different stages of development. So the priorities may be differing across borders, which brings in an important challenge then of how we can cultivate collaboration across sectors on the one hand and across borders on the other. The other key point that really came out is that, as most of you may know, the sense overall in the region is that the status quo of the system in place for now is very much state-centered as opposed to people-centered. So what are the kinds of mechanisms that can begin to reverse these patterns of thinking and these focuses? An example from Thailand is just the very small number of pro bono seats within the system in comparison to the number of lawyers that are going through training programs and certification programs. Of course, however, we see this emerging number of examples from the region of cases of citizen-led, in oftentimes cases, trying to drive people-centered solutions that try to fill in these gaps and experiences of justice seekers. So just to share a few of those, we identified and spoke with some of the drivers of some of these very small-scale innovations that we hope an ecosystem can help potentiate their scaling. And along with that, then we see kind of this role of non-state actors as well in coming into the systems, identifying ways where programming can be done in ways that prioritize justice seekers along the way. Again, it may not be necessarily kind of integrated with justice systems within government. And so this challenge of being able to connect civil society or third-party interventions with public-led systems is very important, and very important challenge that the ecosystem should prioritize. An important challenge is that the shortage of innovators in the region. Where are those individuals that are being trained to think in these ways on the one hand, and incentivized and encouraged to do so and follow the creative process that is required to drive these ideas? We see a general sense that this is very small in scale at the moment, and it's not very geographically distributed in an even way. So what are some of the ways that we can better engage youth on the one hand to cultivate this culture, but also challenge some of the hierarchical structures that are within the system to create mechanisms for folks to have the space to be creative and think in new ways about this. Access to mentors and access to finance is, of course, other key points. And access to enabling policies is also kind of a key catalyzer in the process, where we see rigid procurement procedures in place in the region that may not have clauses that incentivize people-centered or citizen-led type of solutions on the one hand, but also changing the focal points of who are the points of contact in some of the processes that are being put in place. What is the degree of continuity of policy interventions when governments change, and who are the individuals that are in charge of taking on and leading some of the processes that are being put forth by a given administration or by a given individual who might be appointed to sit in a given position for a limited period of time is also an important challenge. Linked to that, of course, then is the access to finance. And we see that a little bit over a third of those who identified being part of the process in innovation report that the types of funding that is available to them does not exactly meet the needs of the stage of development in which they are on the one hand, or the types of interventions that they're trying to pilot or to implement, and the types of funding streams and the language that is being used may not always be prioritizing grassroots-led pilot programs, interventions, or those who might be sitting in more remote areas and may not have access to connections or access to kind of training on how to access finance from larger pools of resources. So there's a lot of need to innovate as well within this space among funding organizations to think creatively how we can shift and reverse the focus of how these programs are being led. Another key challenge in the region is the lack of quality data and the lack of transparency between public sector organizations at kind of a national level. But some of the points of view of those who we spoke to highlighted the importance of also breaking the barriers within government institutions domestically to make sure that data and information resources are being shared and building more transparency mechanisms so that data can be channeled into those who might be sitting in a space where they can think creatively around some of these topics on the one hand, or facilitate access to those resources of information to young people or any others who might be driving some of these thoughts. The access to dialogue, knowledge exchange opportunities is also oftentimes not as diverse in terms of who is invited into the rooms, or what is the frequency and nature of those experiences that are being changed, and also what are the kind of level of individuals that are being invited to spaces to facilitate knowledge exchange about how processes are being handled domestically by those who are sitting more at the implementation levels of the justice systems. So just to try to begin to wrap up this idea, then we really see this need to cultivate community within the sector in a continuous way on the one hand, where we begin to ask ourselves some of the questions like who we are, where do we come from, and why we're sitting in this room. What are ways that we can continuously try to challenge ourselves to also open the space for less traditional individuals and less traditional players to come into spaces like this and be able to bring in their ideas, their skills, but also their observations on how innovation can be driven. We think that this process is not linear and it doesn't really follow a 1, 2, 3 type step approach. But one of the things that we're really trying to identify then is how we can accelerate this process and how this iteration of new ways of bringing actors can be done in ways that can deliver on different points and on different levels concurrently. So just to close on this point, the framework that the white paper introduces is an early attempt to begin to outline these layers where we begin by convening actors and trying to channel leadership on the one hand, pipeline innovations, and lead to hopefully identify solutions that can be integrated within the systems at large. I do invite you to again scan the QR code and the banner, or come to the stand at TIJ and read more in depth to the white paper. And so I'll pass it back to Callum now to introduce the panel and carry on some of these ideas with folks. Thank you.
Thanks so much, Jonathan. And yeah, I really encourage everybody to grab a copy of the white paper at the booth at the end of the session. We have some different programs that we're proposing that can practically implement the findings and the insights that have come from this research. So we'd be really interested in also your feedback and engagement, both in the Q&A session at the end and then also afterwards. We'll be around for the rest of the day and tomorrow as well to pick our brains on this. But maybe now we can transition towards the panel session, where we can also bring into the conversation actually some of the stakeholders we've engaged throughout this process and some key people who are both playing the roles that the researchers identified and are key leaders within the justice innovation space in Southeast Asia as well. So first up, I would like to please invite to the stage Dr. Arsa Ilmi Budiati, who is the Executive Director of the Indonesia Judicial Research Society. IJRS is a Jakarta-based NGO focused on research, advocacy, and legal empowerment, and she has led innovative research in Indonesia's legal sector, emphasizing a people-centered approach in projects like Access to Justice Index, Legal Needs Survey, and Law Development Index, and the Human Rights Index. So let's have a big round of applause for Dr. Arsa. Next to the stage, I'd like to invite Dr. Bunwara Sumano, who serves as a Senior Research Fellow and Head of Social Development Policy Team at the Thailand Development Research Institute. And her research interests include social investment, ASEAN, labour rights and migration, as well as gender equality. And Dr. Bunwara earned her PhD from the School of Politics and International Relations at Queen Mary, the University of London, and an MA in International Affairs from the Australian National University. Big round of applause for Dr. Bunwara. And next up we have Mr. Tim Fernandez, who's a senior leader in the legal, professional and technology solutions industry. And he's currently serving as head of a strategic content development for Asia at LexisNexis. And he develops and oversees an integrated content strategy aligned with business objectives and leads regional content efforts in artificial intelligence and new technologies. But he's also very passionate about coaching and mentoring and is committed to people development and social responsibility. So a big round of applause, please, for Mr. Fernandez. And last but definitely not least, please welcome on stage Mr. Billy Gorter, who is the Executive Director and founder of This Life, a non-governmental organisation that focuses on people-centred justice initiatives in Cambodia. His work has transformed justice systems to better serve vulnerable populations, particularly by establishing child-friendly spaces in prisons for incarcerated mothers and their children. And under his leadership, This Life has developed innovative community-driven approaches to justice reform, including alternative programs to custodial sentences and support for families impacted by incarceration. So a big round of applause, please, for Billy. So thanks so much for being patient and listening to our presentation. Maybe Arsa, I can start with you if that's okay. And given your research and experience, particularly from the academia side, I mean, just to put it bluntly, do you see any relevance in this conversation and this topic of an innovation ecosystem for people-centered justice?
Yes, thank you, Callum. Maybe since yesterday we have explored the importance of people-centered justice, so I won't be going over that again. Instead, to understand why we need to constantly innovate on people-centered justice, let me take you down to memory lane. A few years back, the focus of access to justice or justice sector itself on building formal institution, strengthening pro bono services and bars of lawyers, and reforming criminal justice mechanism, like uniform sentencing guideline and stuff. Those efforts were heavily institutionalized based, state-based, and top-down, emphasizing the rule of law principles. But again, I have to ask, who is justice for? I think it's for the people. So today I highlight 3 reasons why innovation in people-centered justice is essential and relevant to our works in here. First, innovation helps us address the root causes. In Indonesia, for example, the government expanded legal aid and access to courts, assuming availability would mean accessibility. However, our legal needs surveys research in 2019 shows that 99% didn't even understand what is legal aid organization. 62% of them avoided seeking help because they felt justice process was too complex and discouraging. So we shifted our approach, not just expanding legal aid organizations, but making them known, accessible, and quality focused. Following up on this, we now also have a budget mechanism that needs space and gender responsive to meet the needs. Additionally, we saw that justice seekers often lack support for recovery as well, with only 0.1% of victims actually requesting recovery funds. So we're now promoting the Victim Trust Fund and the Environmental Endowment Fund alongside to the government and also philanthropists as sustainable and innovative financing solution for victims of sexual violence and environmental crimes. In essence, promoting innovation forces us to continuously find more suitable solutions to growing problems in society. Second, innovation creates sustainable collaborative access to justice. Many assume that digitizing legal services will simplify access. Yet, our 2023 research shows that most of the justice seekers cannot access the online mechanism that are provided by the government. In response to that, we're developing a one-stop legal information, a portal with CSOs and development partners and government, a kind of Google with legal information provided, straightforward answers, and legal aid organization referrals when needed. We also found that justice seekers and law enforcers alike lack essential knowledge about navigating justice system, especially for the marginalized groups. We're working with the universities, with the lawyers, paralegals to build legal empowerment and train law enforcers, ensuring justice is accessible and also user-friendly. Additionally, we've also tapped into the open government platform, allowing civil society to co-create with the government, nurturing collaboration from local to global levels for long-term policy reform. In other words, continuous innovation opens new opportunities and expands networks, enabling the promotion of more open justice system. And finally, innovation allows better resource allocation. Up until now, Indonesian government, for example, we have been focused heavily on infrastructure, creating institutions, and expanding facilities. However, our research finding in 2022 until 2024 revealed that within the institution itself, the corruption is still remain unsolved. The criminal data is still scattered. The budgets are not based on the needs. This is exacerbated by the punitive approach that has been used heavily, which is very costly for both government and also the justice seekers, financially, socially, and also psychologically. That's why we're partnering with economic experts and the government on a cost of justice study for narcotic crimes, one of the most common crimes in Indonesia, to understand how much are the costs of the government to handle the whole process of drug cases handling, both legally and illegally, while also measure the cost of justice seekers for inmates and families in dealing with the cases. We are trying to quantify the psychological and the social costs, as well as to understanding the bigger picture of the cost experienced by the inmates and also the families. In the end, we are trying to create a comparison model on how much the government can save if they have alternative sanctions other than imprisonment. Additionally, we're currently monitoring SDG 16 as well through Access to Justice Index and Human Rights Index that never been done before, which provide crucial insights into milestones and areas needing improvement. This effort have proven valuable for reform, and the resource now being prioritized in this area and even being expanded for the local measurement. In conclusion, innovating for people-centered justice is always worth the effort. It allows us to rediscover justice in ways we've never seen before, creating systems that genuinely work for the people. Thank you.
Brilliant. Thank you so much, Arsene. And just to summarize that, you mentioned about the opportunity to really drive down into the root causes, the opportunities for sustainable collaborative initiatives, how we can identify new opportunities for people-centered justice, and also more efficient resource allocation opportunities there as well. And maybe I'd like to segue here over to you, Tim, if this is all right. And you've worked in across a plethora of different justice projects, access to justice initiatives. But from your perspective, when did you really zoom in on this, on the importance of people-centered justice approaches?
Yeah, thank you for that question, Callum. I think for me, I've been fortunate. I've worked over 15 years with LexisNexis, and I had first-hand experience that shaped my view on prioritizing people-centered innovation.
one experience that stuck with me was witnessing the impact of the mobile courts program in East Malaysia. This program was heavily centered and focused on the plight of stateless individuals in the rural areas of Sabah and Sarawak. All of us delegates here are citizens of member states. Imagine just for 1 second that you do not have this basic right of citizenship. Just because of the location where you were born. Imagine not having a passport or an identity card. Unfortunately, in the rural communities of Sabah and Sarawak, this is a harsh reality. Many individuals are stateless due to the remote locations of their villages, which prevent them from accessing public hospitals and government departments. Without citizenship, these communities are deprived of basic rights such as public health care, education, employment, and other economic opportunities. To address this access to legal remedy issue, the courts of Sabah and Sarawak, under the leadership of former Chief Justice of Malaysia, Tun Richard Malanjun, initiated the Mobile Courts Program. This innovative program brought court officers, volunteer lawyers, and officers from the National Registry Department directly to these remote villages. They conducted hearings for late birth registration and citizenship issues, ensuring individuals who were previously unable to access these services could now have their cases heard and resolved. Additionally, the officers provided legal aid for other matters, offering comprehensive support to the communities. Witnessing the dedication and effort of the justice system to bring legal remedies directly to the people who were otherwise unable to access them had a profound impact on me and my team at LexisNexis. Seeing the tangible difference it made in people's life was incredibly inspiring. There were children who could take national exams, who could represent their states, their countries. There were people who could go for an operation in a public hospital. And these were life-changing moments, and this was life-changing for these communities. Right? I think witnessing, it is highlighted the importance of making justice accessible to all, regardless of their location or circumstances. Since then, LexisNexis has been supporting the Mobile Courts Program. We have leveraged our expertise in legal content and community support programs to assist in various capacities. This experience underscores the critical need for people-centered approach in the justice system, ensuring that everyone, no matter their circumstances, has access to their fundamental rights and legal remedy. Thank you.
Thank you so much for sharing that story with us, Tim. And I think it's so pertinent in highlighting that we're not talking about innovation for innovation's sake, right? This is about solving those difficult problems that conventional approaches have ignored, and the exponential impact that can come off the back of solving these tricky problems at specific leverage points. And Billy, maybe I can bring you into the conversation here as well, because This Life has been an organization I've definitely admired, and would love to hear about some of the innovative programs that you've been doing from a people-centered justice perspective in Cambodia.
Sure. Thank you, Callum, and thanks everyone for coming and listening to our talks today. I'm just going to shuffle forward in my seat a little bit because I'm going to identify a few things. One is like the profound failure of our justice systems, and that's the reason why we're really here during this conference. But the next is the pathway and the proven pathways forward. So I would like to share This Life's experience in regards to this matter. Before I go into like the three specific programs I'd like to cover, This Life has created a child-friendly space in a Cambodian prison after we conducted research. Our research revealed a disturbing truth, that children were accompanying their mothers into prison, not because it was the best option, but because often it was the only option. So you have children as young as 1, 2, 3 accompanying their mothers into prison and growing up in a prison environment behind bars. So our organisation is very much research focused, but we also work on the ground directly with beneficiaries, with clients, with people. I'll just give you a bit of background into the context of Cambodia. When we started the This Life Beyond Bars program in 2009, the recidivism rate, the reoffending rate for children coming out of Siem Reap prison was 60% within 6 months. So that means 6 out of 10 children were going back into prison after just being out of prison for a short time. This program's been running ever since. It's used a community-driven dialogue approach to understand the problems, the root causes, and possible solutions. And we've been able to reduce that recidivism rate from 60% down to under 2%. The only reason why this works is because it's the communities who are identifying the problems in the first place. It's the communities, it's the people who are impacted by the justice system themselves participating. It's the courts, it's the judges, it's the Cambodian government also participating to ensure that these fundamental rights and the deprivation of liberty doesn't impact individuals as it currently is. Through this program, we've supported thousands of children in Cambodia. I just like more context. In Cambodia, in 2002, the country drafted the juvenile justice laws. It wasn't until 2017 that the juvenile justice laws were actually enacted. In 2019, even though the juvenile justice laws provided provisions for diversion, there was 0 diversion cases accessible to children in Cambodia. That changed with our research called No Place for a Child, Alternatives to Imprisoning Children in Cambodia. We spoke with judges, prosecutors, courts, communities, individuals who are impacted by the justice system. We spoke about diversion and what diversion meant. We were surprised to really see that communities were responding really wholeheartedly and supportive of a diversion program for non-violent, small crimes. It was in 2021 that we started to work on the first diversion programs in Cambodia. The catalyst to change, working directly with the Ministry of Social Affairs, Veterans and Youth Rehabilitation. Through this, we've now diverted and supported over 300 children in the last 2 years from serving custodial sentences. Now, this is a huge improvement in the justice system in Cambodia. It couldn't have been done without the support of the Cambodian government. Unfortunately, I should be sharing this stage with members of the ministry. However, it seems that during this conference, the Cambodian ministry and government is rather underrepresented, and I hope to see that change in the future. There are other initiatives that we run as well, working directly with children who are serving custodial sentences in prisons, and the most fundamental improvement that we can make for those children is to connect them with their families. Prisons are a very scary place. They're a scary place if you're from a poor or impoverished background. To get through to see your children in prison, there's a cost associated with that. And that's globally, there's a cost associated. You may need to take time off work. You may need to travel on a bus, on a train, drive your car. It's a cost that's associated with that. But really, the connection to family is what has made our program so successful. When families are engaged, when families are listened to, you'll see dramatic changes in recidivism and dramatic changes in the way that justice reform can be approached.
Fantastic. Well, thank you so much, Billy, for sharing this in. I mean, I really liked how at the start there you emphasized the point of from evidence to action. You know, that we need to have this connection between research-based and data and the implementation then of innovations. And I think the results are are really there to be seen, as you've highlighted, but also the importance of participatory approaches and collaboration across different stakeholder groups as well. All different themes that we've really been emphasizing in the need for an innovation ecosystem. But maybe, Dr. Bunwara, I can bring you into the conversation here as well, because I think we've established the need and the relevance and the fact that innovations are already happening. So how do we get some money together for this? And from your expertise on social finance across a number of different sectors, do you have any kind of innovative financing ideas that you could share with us?
Thank you, Callum. I have to admit that when Callum first invited me to join this panel, I checked the panelists, I Googled their profile and read their inspiring story and wonder what can an earth add to this session. I think from my research and experience in trying to push for innovative financing models in Thailand, the key thing that I learned is that any innovative idea has to be blended with the traditional way of work or how the thing works, but just present it in a different angle that people would easily accept it. For example, traditionally, Thai people are among the most generous in the world. If you follow the report by Charity AIDS Foundation, World's Giving Index, Thailand has always been one of the top 10. In some years, we are the top 3. In terms of donation, we don't have the official statistics, but based on the socioeconomic survey, Thai people donate every month around 400 baht, and that's around 80 billion baht annually. So around 2.5 billion US dollar per year of donation. The donation money is very fragmented. It lacks of monitoring, it lacks of evaluation where the money goes to and whether or not the outcome that the people who donate the money actually happen. So we try to manage this donation money in a way that would see the outcome more clearly. And we started to see some innovative ways in Thailand. Some of you might have heard about Thejai.com. It's a crowdfunding platform in Thailand. You can Google it, and on this platform, you will see several social development projects. And in each project, they will tell you how much money they need and how they're going to spend that money. And you can even monitor the process and whether or not it meets the objective of the fundraising. And another example is, I'm sure many of you have heard about the Peterborough Social Impact Bond in the UK. So basically, there would be an investor who provide upfront investment or the money to run a program, and the social service provider would use this money, which is more flexible comparing to the state's budget, to work towards the agreed outcome. And if the project becomes successful, the outcome actually happen as agreed, the payer at the end, usually the government, would repay the investor. This kind of model has been implemented in more than 30 countries around the world, and Thailand is experimenting one pilot project this year on early childhood development. So we are in the process of scaling up this project. And another example of innovative ways is the payment for ecosystem services. I'm not sure if you are familiar, but if you work on the issue of climate justice, you might have come across this model in many countries. I think that there are a couple in Vietnam and other countries in Southeast Asia as well. Thailand is experimenting with one project in Chiang Mai. Basically, payment for ecosystem service is based on the beneficiary pays principle. So it's the opposite of the polluter pays principle. Instead of those who do harm to the environment would pay, which kind of be a punishment, and those who pay would have the feeling like, oh, I pay because I am being punished, which is a very negative kind of thing, and that's why they would want to avoid it, because nobody wants to be punished. We switch it into the beneficiaries pay. And I think everybody benefit from good environment, good air quality, clean water. So when we communicate this principle, more people would accept it more in a more friendly, more, yeah, I do benefit from the less air pollution. And I think these kind of models can be shared and learned and even adopted in many areas. So yeah, I think we also need to learn from other countries, because I understand that many countries also have many innovative models in terms of utilizing the money. For example, Japan has launched the fund of funds. They use the dormant bank accounts, meaning that the account that doesn't have any transaction and just lay there at the banks. They use it for social development projects. I think there are a lot of potentials that we can explore. Yes.
Thanks so much. And I mean, I think you've definitely proven why you were the right invite to the panel. But just to pick up on a couple of key points you mentioned there about when we talk about finance and innovative financing mechanisms, we can't forget the importance of data and monitoring and evaluation as well, because this is what justifies the investments of the money in the first place. I really encourage everybody, if you don't know it already, to look into the Peterborough model of social impact bonds for prisoner reintegration. This is a very interesting financing mechanism. And also I appreciate your call to action as well, both to look to other countries and around the world, but also to look at what's happening in other sectors as well, and to think about how we can apply innovations, whether it's in the environmental sector, whether it's in inclusive development, and apply this to the justice sector when it comes to mobilizing more funds as well. Brilliant. So myself included, we've all gone way over time on the first round of questions, so we need to be a little bit sharper in this second round. But Asa, I'm not going to help here because it's a difficult question. But from some of the barriers that you've seen for people-centered justice in Indonesia and in the region, how can an innovation ecosystem help?
Okay, thank you, Callum. Earlier, I might have mentioned some examples on how justice innovation can overcome some barriers in ensuring people-centered justice, but I want to highlight some points on how justice innovation ecosystem is actually can work on solving problems in the bigger picture. We recognize that many obstacles remain in mainstreaming people-centered justice approach within the justice sectors. This included limited capacity, scarce resources, a lack of recognition and understanding on where to begin, insufficient political support, and persistent gaps in basic rights and welfare. These issues form a complex, interconnected cycle. Without intentional effort, this cycle is difficult to break, leaving us locked in the repetitive patterns, and this is why innovation is essential, to untangle this complex web of barriers. Let's start from the upstream. One of the biggest challenge government agencies face is currently about collaboration. Agencies to work in silos, often struggling to open up to another, even with the same sectors. And one of the platform that should be available to everyone is regarding the open government platform, which in Indonesia, it provides a promising model by bridging government and civil society organization. And this platform fosters much needed cross-sectors collaboration and aligns effort towards shared goals. And financial resources are also often cited as another significant hurdle. With state budgets largely dependent on tax revenue, it's understandable that government funding is limited. To overcome this, there's a need to explore sustainable financing mechanisms, just like Yui said earlier, that look beyond the traditional budgets, creating new funding streams that can support people-centered justice more robustly. And additionally, outdated data presents a persistent issue in policy reform. Without access to current information, policy change lack the foundation needed for impactful decision-making. Here in Indonesia, we try to conduct many innovative research collaboration between government and CSOs that have proven effective and should be expanded and strengthened to create a more informed policy landscape. Far from the upstream, where the government and civil society met, there is an area where they are making strides in adapting justice system to be more inclusive, especially for marginalized groups. CSOs, paralegals, lawyers, and academics are joining forces to adjust systems so they better serve these communities. Understanding their perspective and needs of marginalized groups requires innovation and empathy. This approach not only emphasizes people-centered justice, but also paves the way for new solutions that achieve outcomes previously unseen. When it comes to measuring success, the traditional reliance on budget absorption and general satisfaction surveys often fails to capture meaningful impact. Shifting evaluation methods to reflect institutional performance through tools like legal needs surveys, indices, in-depth interviews, and even social media analytics offer a more accurate measure of progress. These methods provide solid basis for reforming institutions to be more accessible and user-friendly. And finally, focusing on the downstream, innovation must address the needs of the people, particularly those from low to middle income backgrounds, who make up the majority of the justice seekers. Innovation doesn't need to be complex or flashy, it should be practical. For example, legal insurance modeled after health insurance is one idea under consideration. Additionally, increasing welfare is a key aspect of minimizing legal issues from arising in the first place. Empowering communities themselves must also be approached innovatively. As societies' needs grow more complex, sustainable approach to legal empowerment are essential. Building on principles of knowing, using, and shaping the law ensures communities have the knowledge and capacity to advocate for justice responsibly. This empowerment enables people to find their own pathways to justice, while the state recognizes and regulates this process in line with human rights principles. In conclusion, building a justice innovation ecosystem allows us to address these barriers in a comprehensive way, creating new opportunities for people-centered justice that meets the needs of the people and builds a more accessible and effective justice system. Calum, thank you.
Fantastic. Thank you so much for highlighting these insightful points. And Billy, maybe I can bring you into the the conversation here. And, how can we really foster this collaborative innovation ecosystem and drive collaboration between different stakeholders?
Thank you. This can be potentially a bit of a loaded question, considering the region that we work in. Civil society and government, there's been quite a bit of tension there. It's probably as old as democracy itself. But there are ways for government and civil society to work together, even in shrinking landscapes or in countries where it's a restricted environment. But first I want to say that there's no one-size-fits-all approach to civil society working with governments. And in many contexts globally, the very notion of civil society and government collaboration actually seems impossible. You only need to look at Gaza, for example, or Myanmar as another. But I will focus on the important question, which is in regards to Cambodia and how we've done it in Cambodia. So when we've conducted research like No Place for a Child, Alternatives to Imprisoning Children in Cambodia, we took that research to the ministry and we literally held our breath, not knowing what the ministry's response would be to this research. Because this research was introducing something very new. This research was demonstrating a community's willingness to try something different, something new, something that's within the law. We didn't expect, really, to be honest, the ministry to wholeheartedly welcome us as civil society and plan to work with us to address the issues of diversion and alternatives to custodial sentences for children in Cambodia. So for civil society, we've learned that you need to build trust through evidence. If you can build trust through evidence, we found that governments will listen. You need to demonstrate professionalism and rigor. You need to develop a mutual understanding of what the issue is. The government sees us as a partner, but not as a critic. We can have closed-door conversations with the government to express some of the concerns that we have. We need to find common ground in child welfare and welfare responses. We need to have regular meetings with ministries, civil society, the government, and so forth. And we need to credit each other for the work that we do and the impact that we have. And if we can do that, then civil society and governments can work together and we can flourish and we can address some really critical issues regarding people-centered justice approaches in the region. We lead with evidence, we build trust transparently, we focus on shared goals, and we share recognition. And I just want to follow up and finish with that the stories that we've heard over the past 2 days remind us really what's at stake. Real lives, real families, real communities. When governments and civil society can move beyond adversarial relationships and focus on human stories, we can create a space for genuine innovation. In Cambodia, this has meant moving forward from a recidivism rate of 60% within 6 months to below 2%. From a zero diversion case model to a model that can be expanded nationally. From institutional resistance to a national scale potential for working with children who are accompanying their mothers into prison. It's not just theory, this is proven practice. And I implore governments to work with your civil societies. I implore civil societies to work with your governments. We need to find common ground because what's at stake is children's futures, women's futures, the future of the world that we live in.
Thank you so much, Billy, and I really, really appreciate the call to action there you're leading with, and I'm going to steal this phrase, trust through evidence, and a mutual understanding and investment in basically relationship building as well across sectors. But maybe Yui, Dr. Bunwara, I can bring you into the conversation again here because innovation doesn't naturally come to all institutions, and I think that's particularly true in many justice institutions. But maybe from your broader experience, how can we incentivize innovative approaches, incentivize innovative actions to come into the ecosystem?
Thank you, Callum. I think at least in the context of Thailand, there are a lot of incentives for individual or for private sector to take innovative projects. It's in the nature of businesses to find new ways, new solution, innovative ways to work with the less resource and maximize profit, whether that's financial or social. And for individuals as well, we have a long list of items that can be used for income tax reduction or exemption in some cases. So I think many actors, many stakeholders have already incentives for them. The public sector, on the other hand, the government, I think, is the party that needs the most incentive to adopt innovative approach. They need to think about the potential of new ways, new techniques, how their works can change without doing the same thing, doing the routine work. And it's going to be difficult to do so if there's a lack of accountability, or if we can, or I can dare say, to a bigger scope, is the lack of rule of law. So I think the government needs some incentive to think about the outcome of their own action, the outcome that actually happened to the people, instead of having the same old output-oriented activities. And I have to say that unfortunately, the government is not known for the fast changer. And that's why it's going to be my turn for the call for action. The non-governmental actors are very essential to lead the way. We will have to experiment with the innovative models, the solutions that are working best for the people, and use that to help the government, because trust me, a lot of public officials really want to change, but there are other structure, the laws, the rules, the traditions that they can't break easily. So if the non-governmental actors have proven projects with data and evidence, that will help the government a lot. That's the incentive for them so they can officially claim that this is the change that they are going to implement. Yeah.
Fantastic, and I think you highlight a key relationship there between innovation and accountability as well, when failure is a natural consequence of some innovations as well. So how do we build in that space? and again, linking back to this importance of collaboration as well between the third sector and the public sector. But Tim, to bring you into the conversation here as well, we can't be talking about innovation here without bringing in the topic of technology as well, right? But does people-centered innovation and technological innovation, are they two ends of the spectrum, or can they be brought together? What's your perspectives on this?
Yeah, that's an interesting question, Callum. I think for me, personally, I think they're not opposites. They're not the different ends of the spectrum. In fact, they're highly complementary. I would argue that any successful innovation would always be centered around people. We can take examples such as digital platforms for case management. It improves the efficiencies of the court, but it also improves quicker turnaround time for people to access legal remedy. Right? For example, another example would be platforms for publishing cases and legislation. I think that provides access not only for the administrators, but also for the general public to actually access this case law and access the legislation. Right. Another concept that I have is legal aid AI chatbots. We all know legal aid clinics are some of the most underfunded and under-resourced groups, right? And if we have legal aid chatbots that can answer the most simple questions on property transfer, how to set up a business legally, a few simple legal questions, I feel like this would free up time within the legal aid group to actually do more complex work or to address more issues within the group. Right? So I feel like these are examples where it's complementary. And I think a word of caution when implementing solutions is it's critical not to start with the solution. The best practice is to always start with the problem and accurately define the problem statement. This role can be seen in actually Jonathan's, the white paper that Jonathan just presented, right? This role is typically played by the issue champions. Always to engage key stakeholders that would be using the systems as well as those that would be benefiting from the output of the systems. One story I could share is where people were more jumping to the solution was in Myanmar. I had an experience working with the Supreme Court of Myanmar. At the time, we were sent to publish the commercial court cases. And we went to this IT department. We were sent to the IT department of the Supreme Court. And they had 3 people there. And this was under-resourced, underfunded, and they were supposed to publish the entire judgments of the Supreme Court, right? And when we went there were 8 agencies that gave them 15 different systems, and none of them worked end-to-end. All of them did part of the role, but no one could publish the cases from the time of inception to execution. And when I went there, I said, me and my team, I said, we're not going to build the 16 system. We're going to use what they have, and we're going to actually customize it to fit their needs. And we journey map, we actually worked on their use case, we worked on their pain points, and we actually customized the system to actually fit what they wanted to do with it. And just before launching it, there was the military coup in Myanmar, and we couldn't officially launch it. But a few months later, I saw judgments being uploaded, and I felt like that was a success to me. Right? Ultimately, the goal is to ensure that technological advancements are designed and implemented with a clear understanding of their impact on people. leading to a more just and equitable system.
Fantastic. Thank you, Tim. And I love it when you guys do my job for me, because it's a perfect summary that any successful innovation needs to be centered around people. Thank you so much for emphasizing that point, and a great way to kind of come to an end of this initial part of the panel discussion, and maybe go to a second part now, where we have a slightly bigger panel, which is our audience here. So it would be really appreciated if anybody has any questions or comments or thoughts. And I see a first hand over here, and then we'll go to the gentleman at the back afterwards, please.
Okay. Can anyone hear me?
Yes.
Okay, good. Okay. Hello, everyone. My name is Putri Diva Zafira. I'm a student of Sumpah Pemuda School of Law, and I'm in the 5th semester. And yeah, so I do have something that I'd like to share, if that's all right. Okay. Especially from what I hear from Miss Arsa. Yeah, so I'd like to share first that, first of all, yes, I am interested in about the issue regarding about what's happening in Indonesia, especially about how gender discrimination and sexual harassment is sadly still a thing in Indonesia, and corruption is still a thing. However, such of those issues are sadly tend to be overlooked. And if it's all right if I share my experience, so first things first, I'm actually a double degree student, so I'm also a student of Sriwijaya University in South Sumatra, majoring in international relations. So one of the justice innovation example that I can see in my other university, so there is sadly sexual harassment and sexual discrimination happening in my university, sadly, and one of the recent cases that's happening in my university was there was one of the student council in my university that sadly committed such of those crimes against the female students. It's been happening for a year back then, but fortunately everyone is able to voice the issue that's happening there, especially the head of the student council at my university. So yes, because it does show that, well, although that it's tend to be overlooked, but now we managed to voice such issue to our rector, which then leads to the person that dropped out of university. So what I'm trying to share is that is one of the examples that I can share about the justice innovation happening in my university. Started when such of those issues weren't actually being voiced out to the whole university, because because the person had respectable roles as a coverage of their crime, which is sadly not an excuse, and eventually not only the student council, but every one of the students, including my friends, and one of them joined a journalist organization where they voice out that issue to the whole university. So with the participant of the staffs and the student council, the organization, and every student, including myself, we are able to voice out that issue to a rector, and leading to the student to consequently drop out of our university for the safety of our students. And yeah, so that is one of the things that I can share in the midst of Indonesia, sadly with having such of those issues overlooked. But yes, it shows that justice innovation is truly needed, especially justice in people-centered way. And which then leads me to a question. Is there still hope for Indonesia? Can they able to implement the justice innovation in a way that doesn't undermine the human element of empathy and discretion that is often crucial in legal decision-making? Thank you.
Thank you so much. And maybe we can, I think answer this question is for you, but maybe we can just quickly group some questions. So, sir at the back, if you can go quickly, and then we'll go to the gentleman here to the right, and then to the lady at the front here. And if you can keep your questions
Sure.
short.
Thank you very much for sharing good practices. I'm, always encouraged to see and hear, the practice that Indonesia has introduced so far. They have the national, strategy and access to justice. I'm sure, it is still continued. And that is a good kind of means to, demonstrate the collaborative approach between the government and the non-government agencies. So my question here is, there are two things that you've shared. One is from Indonesia and one from Malaysia, I guess. The Malaysia, you have mobile court system. It was discussed yesterday as well. Our constitution, though, doesn't very much clear, but there is a provision that, government, I would say, like concerned state mechanism can come up with a people-centered, justice mechanism. We have a judicial committee at this moment of time, but hopefully, like constitution may get revived, to get there. So I wanted to know, how the mobile court system is operated, the modus operandi, if I may. And the second question.
Sorry, sir, if we can just keep one question. We're in between lunch.
Okay, no, this is linked with the first one. Very briefly, it's about one-stop services. We're trying to, introduce it in Nepal in the name of grievance handling system with certain level of innovation in it. So again, the question is same, the modus operandi, the procedure, operation, how it works, and what kind of, to what extent that ownership from the government is there over it. Thank you.
Fantastic. So, Tim, I think this question will be for you. Gentleman at the back.
Thank you. So we hear the speakers discuss the current challenges and trends. My question is, what strategies do you see as effective for building healthy partnerships among government, civil society, and the private sector? And more importantly, what role do you think international partnership and regional institutions can actually play in building a more interconnected justice ecosystem in Southeast Asia?
Fantastic. Thank you very much, sir. And Madam at the front.
Thank you very much. Thank you, Dr. Bonwara, for sharing those alternative and innovative financing mechanisms. My question really relates to, do you have case studies, examples of how other sectors quickly manage to innovate and change to alternative, innovative financing mechanisms? Because I know for sure in justice, this is really very, very slow. Perhaps, you gave examples that include, with health, let's say social welfare, environment, and so on. So basically, what have been some of the factors that catalyzed that quick change to be able to use alternative and innovative financing mechanisms? Thank you.
Fantastic. And I think we have one question for each panelist, so a nice spread. Maybe to give you some thinking time, Arsa, would you like to start with the question from Indonesia?
Okay, thank you, Callum, and thank you, Miss, for the question. Thank you for sharing as well. And the question is there is still hope for Indonesia? Of course, yes. Optimism, one thing is optimism is one key important factors for innovation, I think. Just to share some good practices in Indonesia, we in 2022 we enacted new anti-sexual violence law, and the law was enacted together with the government and also with the CSOs, the formulation of the law. So there are many good breakthrough in the law regarding the anti-sexual violence. So currently, the CSOs and the government join hands to create a mechanism, starting for the reporting mechanism, more inclusive reporting mechanism, and also the thing that I said before, that currently we are developing the victim trust fund mechanism. So they have innovative financing to ensure the protection and the recovery mechanism for the victims. So there are many breakthroughs that need to be followed up. The implementation will be tricky because as we understand, there are still challenges in the perspective of the legal enforcer, the perspective of the government itself. There are still not quite a gender responsive and stuff. So that's the thing that we have identified and continuously being improved together with the government, because we understand from the civil society organization we can only do so much, but the government, they have the they are the decision maker, they have the resources and stuff. So like Billy said before, that we have to divide the role between us, the SOs, and the government to ensure the implementation of the certain law. But again, I will remain optimistic about the improvement of the sexual harassment and violence protection mechanism in Indonesia, because we have those new law and there are a lot of homework and collaboration towards the implementation of those law. So yes, that's maybe some answers for me, Callum.
Thank you so much, Arta, for sharing. And maybe Tim, I can come to you here for the questions on the operational aspects of the Malaysian court intervention.
Yeah, I think sharing the operational aspects, right? I wouldn't go straight to copying an operational model from one region to another, because there's going to be nuances to each region. There's going to be different needs. In all projects, you usually start with the scope, the resources, and the timeline that you want to execute on. But when you look at these projects, these justice system projects, you may encounter things like language, vernacular language. You might encounter things like, for example, in Sabah, there was geographical issues. They couldn't access the court because of the remoteness, because of rivers, because of valleys that they couldn't cross, right? So there are different resources that we needed to pull together to actually make that happen. So I would actually encourage anyone working on an operational model to workshop it, but also to kind of have a working group with the relevant stakeholders to really understand their needs and really get to the root of their problem and find the gaps. So I think that's where the model that hopefully that would come together actually looks at empathizing and working with the different stakeholders. That's me.
Fantastic. And if I can offer on your behalf, Tim, maybe this could be an interesting discussion in follow-up to the panel over lunch as well. And maybe Yui, I can go to you and from the financing question.
Thank you very much for the questions. I'm going to link the two questions about partnership and how to catalyze innovative financing model. I would like to use the example of Peterborough social impact bond. When it first started, it's basically because of the records of data on how the people who exit the prison would go back into the same prison within 6 months or something. And that shows that the same old ways of trying to reduce the reoffending rate was not working. So the government then realized that they need to find a new way, but that is proven by the data. Also, it needs a new way of communication, the message. I would like to use the example of the Equitable Education Fund in Thailand, which is piloting a kind of social impact bond in early childhood development in Thailand. Traditionally, the Equitable Education Fund only focus mainly on the education system, meaning they would mainly focus on bringing back the students into the education system, into the schools, basically. They hadn't really thought about the early childhood development because that's the preschool age, basically. But they also see from the data that unless we improve the early childhood development, those who enter schools will fare much worse than those that had been undergoing the proper early childhood development. So it is in their interest. It is actually the preventive measure. They would use less budget in bringing back the students because by that time it would be too late. So it's the same data that shows kind of failure for some people, but instead we can communicate it in a way that this is the opportunity that you can save the budget, that your work will be much easier. So those would be two catalysts: communication and the data. And the next step would be building partnership, how to bring people to work together. And believe it or not, we already have the formula to build trust. Trust is basically credibility plus reliability plus intimacy, and divide that with self-orientation. Credibility is basically if you can show your partners that you know about that topic, that you have the solution, that you have the records of doing this. That's credibility. Intimacy, that requires talking, series of discussion that you can understand each other, that you will be closer, you will know your partner better. Reliability is, and again, the record that, to show that you can meet the deadlines, to show that you can deliver the objectives, and self-orientation is basically that all that you've been doing is in the mutual interest of everyone, every stakeholder, is not for your individually. So I think that's the nerdy answer that I can share to you guys, but I'm sure every one of you here also have your own success formula, and we really look forward to learning from all of you. Thank you.
Thank you, and I think that's a very nice segue into the final question, Billy, which I can share to you in terms of mechanisms and techniques for partnerships and the role of international collaboration here as well.
Sure, so I'll try and draw a bit of a picture here in how it's worked for This Life, and in regards to the communities identifying what the problem is, the root cause, possible solutions, and then their priorities. This Life as civil society stepping in and creating programs that address those issues. The Cambodian government now introducing or revising policy on alternative care for children to include children who accompany their mothers into prison as an area that needs to be addressed urgently, and how to bring in private sector into that conversation of those programs. Really, it's looking at direct service provision, policy and regulations, and obviously economic support. The private sector has a wealth of resource that can be made available to civil societies and non-government organisations like This Life, and we encourage you to dip deeply into those large pockets that you have and distribute some of that wealth to the poor and marginalised communities that we represent. I just want to also share in regards to the role that the media plays, and really like share an example of what's happened in Australia recently. State elections have been fought on who can be the toughest on youth crime in Queensland, in the Northern Territory, and now it's happening in Victoria as well. And the media has absolutely created a problem that does not exist in these states. The hysteria that the media has whipped up has created the election issue, and the party that won in Queensland was the party who addressed the issue around, and their motto was, do an adult crime, spend adult time. And we're talking about children here. And I spoke to politicians on both sides of the aisle, and they both were motivated by the media's hysteria around the issue of youth crime. We're seeing like countries like Australia that are developed going backwards, and countries like Cambodia who are developing, moving forwards and being like new regional players and leaders in diversion and alternatives to custodial sentences. It doesn't really make much sense, and the media plays a critical role in addressing that. So governments, civil society, speak to your media, speak to your representatives, and make sure that the truth is out there, and we don't ostracize children in that process to win elections.
Thank you so much for highlighting that very, very important aspect at the end. And I think if we'd had an extra seat on the panel, I think the media is also an interesting player in this. And maybe this is also something we can look at a bit more when we're thinking of innovation ecosystems as well, and the role the media plays. I can hear stomachs rumbling as we are terribly over time and going into lunch. So I'd like to, can we have a big round of applause, please, for our panelists, for these fantastic insights. No, and we will have opportunities to ask more questions, to dive more. After lunch, we have a World Cafe session. So this topic will be there. Please come and join us. Please come and ask more questions and challenge what we've been up to with these wonderful stakeholders and with our partners at the Thailand Institute of Justice. And I'd like to just finish with a few kind of key bullet points, just because I've been listening very intently to everything you've all been saying. The first one is the need for an evidence base. The second one is how can we have the importance of a collaborative community. Problem-driven, not solution-driven. Innovative ways and different and out-of-the-box thinking in terms of value exchanges and mobilizing finance. How can we test solutions in the third sector with civil society organizations and then deploy these into the public sector? And I think one thing that Asa, you mentioned as well, which I really think is the most important message, is that justice innovation is also a message of positivity about the justice sector as well. It's a message of positivity about the value that people-centered justice can bring to justice seekers and stakeholders throughout the sector. So for me, when I listen to the innovations that you're all involved in, and other people at this conference as well, I feel incredibly energized, incredibly motivated about the future and the potential for the justice sector, for people-centered justice, and the role innovation can play. So hopefully that gives everyone a spring in their step to take into lunch, and really thank you all for staying with us, and hopefully we can have a bit more of a chat during the World Cafe and during the rest of the conference. Thanks so much.
Thank you. Just a few announcements to make. Lunch will be served at the same area as yesterday, so it will be on the ground floor. The session in the afternoon will start at 1:30 p.m. So come back to the meeting room A for the World Cafe session and meeting room G for the closed door discussion on the National Human Rights Institution inquiry mechanisms. And a slight change of location on the session after that. We will have the session on SLAP will be in this room, conference room 2, and the session on financing for justice is moved to meeting room A. Thank you so much, everyone. Enjoy lunch, and please continue your conversations.
All right, I'll follow you guys for lunch.
with this. Okay. Okay. Like a close, like I'm talking, okay? Like I'm very important. Chandrika, let's take a like this. Like this.
เริ่มบ่ายสามครับ
Yes,
No, I watched the documentary on Jazeera, yes. And I mean, I am an email communication information center in Madrid. So thanks for accepting our invitation via Vinny, our colleague from UNB Thailand, I think. Yeah. Yes. Yes. Your case is still ongoing. Okay. Wow. Anyway, you have your chance. Someone, one.
Yeah, Professor Dixit?
No, there is another judge.
She's here. She's standing. Yeah. And Joe. Okay, Jesse. Jesse, I'll start, okay?
Just announcements to rooms.
Yeah, okay, I will. Hello, dear participants. Welcome to the last session of today on SLAPS, lawsuit or lawfare, ensuring access to justice in the face of strategic lawsuits against public participation. Just an announcement that a session on financing for justice will be at meeting room A. This one is for SLAPS. I'm pleased to give the floor to Ms. Jessie, Head of Governance of UNDP Malaysia.
Thank you, Thomas. Welcome back, everybody, after your break. I'm pleased to see so many of you here. So this session, we're particularly looking at lawsuit or lawfare, ensuring access to justice in the face of strategic lawsuits against public participation, and its acronym is SLAPS. So I would like to take this opportunity to maybe explain a little bit about SLAP. So SLAP is a growing threat to freedom of expression and access to justice in Asia-Pacific region. What is SLAP? SLAP is frequently deployed by companies. SLAP seeks to manipulate the judicial system by masquerading as legitimate legal claims, abusing laws, i.e. libel or defamation, to target valid and protected speech or protest. SLAPs can be effective in gagging critics. They take advantage of the prohibitive costs and time that it takes to litigate a case, and can result in prison sentences and other harmful physical, financial, and psychological impacts on defenders. These acts have a chilling effect on freedom of expression, disrupt legitimate collective action to defend the rights of workers and communities. Allow me to share an example of a recent SLAP case in Malaysia. In July 2022, two companies whose core business is the extraction and sale of timber and the manufacture of plywood had submitted a claim to the High Court for loss and damage resulting from alleged defamatory statements made against them by an environmental NGO. The plaintiffs claimed that 7 articles published by the NGO on its website between June 2020 and March of 2021 had affected their business and commercial relationships. In the articles, the NGO had reported concerns of members of indigenous peoples communities affected by a 148,000 hectare logging concession awarded to the timber company and promoted an online petition calling for a halt to the project. The concerns relate in the articles related to the certification granted to the project. In filing the claims, the company requested general damages of $500,000 ringgit, which equals to 1.12 million USD, as aggravated damages to be assessed by the court, and in order for the defendants to retract the articles in question and publish an apology approved by the companies. The companies also sought an injunction restraining the NGO from publishing any similar statements concerning them in the future, along with legal costs. I will stop at that because I'm pleased to say that we have 6 distinguished panelists here with me today to help us unpack the issue of SLAPs, identify key challenges, discuss strategies to combat SLAPs, and give us clarity on how courts may address such cases. So I will maybe just introduce them here. We have Honorary Justice Nani Indrawati from the Supreme Court of Indonesia. Okay, we have Honorary Judge Tanayuk Tantiko, Judge of the Office of the President of the Supreme Court, the Office of the Judiciary, Bangkok, Thailand. Okay, right there. And we have Professor Emeritus Vitit Muntabon, UN Special Rapporteur on the Situation of Human Rights in Cambodia, as well as Mr. Joe Hironaka, Advisor or Chief of Unit Communication and Information from the UNESCO Regional Office in Bangkok. And finally, we have Ms. Chutima Sidasatyan, a journalist from Thailand. So our panel is scheduled for 90 minutes, where each speaker can present for 7 to 10 minutes to address the broader goals. And then we will have for a Q&A session for the last 30 minutes of the session. Okay, so allow me to start by maybe inviting Ms. Chutima Sidasatyan, whose, I suppose her background basically is to say she has a long history in journalism, awards for investigative reporting and human rights reporting, as well as exposing issues with the pushback of Rohingya boat people from Thailand. She has extensive experience working with many newspaper companies before from throughout the world. And she has since achieved, she has undergone and got a doctorate, I suppose, in ethnic anthropology and worked as a field producer on the documentary Ghost Fleet, which exposed slavery at sea. She now works as an activist and consultant and divides her time between Thailand and Europe. So, Ms. Chatima, maybe I can invite you to talk about how SLAPs undermine access to justice and freedom of expression, as well as the challenges individuals and organizations face in accessing justice when targeted by SLAPs, given that you have had experience being a person who has been slapped before. So the floor is yours, Ms. Chatima.
Thank you for having me here, and then I'm very happy to share my experience, and then I hope that the Thai government will bring the defamation crime down. So let me share my own story. I have been a victim of Thailand abuse criminal defamation law twice now. After serving over 10 years as both a journalist and an advocate, I believe the only way to get rid of SLAP in Thailand is by repealing criminal law. Anti-slave legislation will simply complicate a legal system that needs to be made as simple as possible. It may be that there are other solutions of other democracy, but I am convinced the criminal defamation law needs to be killed. It needs to be killed in Thailand if our country is to embrace the true freedom of speech. Civil defamation is enough. Civil defamation is enough. It allows people who think they have been wronged to seek justice through the system. But criminal defamation turns people who only aim to is to improve Thailand into quote, criminal unquote, as soon as an accusation is made. I was declared a criminal for the first time 10 years ago, when I and colleagues, a small online news outlet, were sued by the power loyal Thai Navy. Instead of fleeing to other countries, we stayed, we flowed in the court, and we won. The Phuket One trial was the over-publication of a paragraph from Reuters series on human trafficking that won Pulitzer Prize. The Navy could have sued Reuters, which is, it has 10,000 times more readers than Phuket One, but it should go after deleted guys like us. As a result of our victory, the law changes to make it possible to sue both criminal defamation and computer crimes. But in 10 years since that case, many journalists, advocates, and human rights defenders has been sued in Thailand and have been turned into quote, criminal unquote, without being found guilty. I became a criminal again 3 years ago when I was sued by an local official. While working as a volunteer community advocate, I uncovered a corruption scandal. I discovered that many millions has been go some personal pocket. So I blew the whistle and informed the villager of what has happened and told them what they write in score of Facebook posts. I expect the bank, government bank, involved to be graceful, but instead, the bank itself covered up the thief of its own money. That is very shocking. The elected local officer said he's not over scandal, but because of that, some of my posts were personal and political unquote. 3 charges were passed from police to prosecutor, and many months later, I faced the trial. After I was found not guilty, the election local officer sued me 6 more times. Once again, police passed on these charges to the prosecutor without serious investigation. Even the police asking me, what does it hashtag mean? They charged me without understanding. So the policemen, they just quote their duty unquote. That's why they have to receive the charge. This time, my lawyer made submission to the prosecutor because 6 charges were present in 4 cases, which would have been 4 trials. The prosecutor wanted to kill all 6 charges, but the senior provincial prosecutor decided to proceed with 1 charge. How can that be? All the same, similar posts, but keep 1. Go ahead. So 5 charges were dropped, but I am still quote unquote criminal. No date has been set yet for this trial, which will be probably be in 2026. Everything I have done over the past years as a journalist and as advocate has been to make Thailand a fair place and a better country. Yes, here I am. Banded, a criminal without evidence, be in prison and forced endure all kinds hardship until long-awaited trial takes place. Incidentally, the charges related to a hashtag. It will be probably the first time anywhere that a judge has to rule whatever a hashtag can be defamatory. I think we all know the answer. Yes, I have to face another trial for doing the right thing, and for seeking to improve the life of the people in an uneducated farming community. If I was a member of the Thai government, I would seek to improve freedom of expression and reduce slap case by repealing the criminal defamation law as soon as possible. That needs to happen, the good of the country, its reputation, and its citizenship. Sir, civil defamation is enough. Thank you.
Thank you, Ms. Chutima. I really applaud you for your perseverance despite the numerous charges that you have to face throughout the years. Maybe just to follow up with a short question, and in those times when you were facing this, and what type of support do you wish you had had during those times, and if that would have helped you in some ways, despite you facing it on your own, if you don't mind. Thanks.
Thank you. I have to say that it's lucky or not lucky, but actually the defamation crime should not take place at the first in the Royal Thai Navy back in 2013. Yeah, I've been supported by the international organization like Tribals, Media Defenders, ICJ, and so on, and especially local people who've been suffering by the big theft. You know, they have the theft is over $1 million baht, so per each person. They said they in their life, even they never having money, 100,000, but now they have a debt over $1 million. Yeah, I have the stay strong, stay positive, and I keep talking with everybody much as I can, especially all the contact in the past. And then I was thinking that it should be good that I have many organizations helping. It is very tough because we've been traced. Since 2013 until now, I still have the brand of the criminal in my face, even all the charges been dismissed in 2015 of the Royal Thai Navy. So that's why I decided I have to leave the country to working in abroad because I not have the future in Thailand. So thank you very much for the international organization that they are helping and then keep an eye on and then put the spotlight to Thailand, and they hopefully my government will change this or killing this law. Thank you.
Thank you, Ms. Chutima. So maybe I will move on to our second panelist, Professor Emeritus Vitit Muntabon, who is also currently the UN Special Rapporteur on the situation of human rights in Cambodia. So Prof. Vitit is actually he's actually based at the Faculty of Law, Chulalongkorn University, Bangkok. He's a graduate of Oxford University and has held many UN positions throughout the years. So, Prof. Vitit, if I could ask you to speak to us a little bit about the scope of freedom of expression and the context of its limitations, highlighting the motives behind SLAPs, the different goals of businesses and government actors in utilizing this approach. The floor over to you, Prof.
Thank you very much, and I think it's an excellent idea to have a case study, a very serious one that we've just heard in terms of inhibitions on freedom of expression. And with that, the context is really to recognize that many parts of the Asian region, we are witnessing shrinking civic and political space. That's a fact. In Thailand now we have an elected government, but we still have a lot of remnants of the past from the coup still with us. So first message is be careful. Be careful. And with that in mind, let's look at some 10 entry points in terms of how we can exercise our rights, even in that rather constrained space. Number one, it is important to recognize that from a human rights angle, freedom of expression and freedom of association, assembly, these are not absolute rights. They can be constrained. They can be constrained under human rights law. And the constraints on freedom of expression in particular are found in treaties, declarations, Covenant on Civil Rights, Article 19, etc. Basically, the two limitations are, one, defamation, and 2, national security. They are legitimate limitations, subject to interpretation in a moment. So please be careful there. 2, what are the permissible limitations? Defamation can be used as a ground to limit freedom of expression, but we have to interpret it a certain way. National security likewise. And internationally, for these limitations to be legitimate, the government in particular has to prove 3 elements, the so-called 3-part test. The limitation, such as the limit on expression, has to be proven to be legal, principle of legality, meaning it's not discretionary, abusive. It has to be under a certain law, which is compliant with international standards. Secondly, that limitation has to be necessary and proportionate to the circumstances. One little comment on the internet leading to a total shutdown of the internet is totally ridiculous and disproportionate, for example. And thirdly, the element of legitimacy. The limitation must be for a legitimate purpose, for democratic reasons as well as for the rights and duties of others within a certain democracy. And of course, we're faced with a lot of non-democracies in Asia. So, if those are limitations that we have to operationalize, then we have to come to the third element to be borne in mind. That is, we have a whole morass of unnecessary laws. Security laws, blasphemy laws, laws touching certain figures at the top of the system, and infamously, criminal defamation, together with civil defamation, in many Asian countries, even though Europe has got rid of criminal defamation. So, while we will look at SLAPP in a moment, as a consequence, don't forget the root cause of the inhibition. Criminal defamation needs to be done away with, generally. And that is international law, but it's still very much there in many of the countries sitting here, right here in Asia. At most, you may justify civil defamation, but not criminal defamation. But we still have to face that. And so if it's there, criminal defamation, what do we do? As I said yesterday, even before reform of the criminal defamation law, we should press leverage with governments to desist, refrain from using criminal defamation. But we have another entry point, and that is it's not just a question of governments anymore. SLAPP cases that you will hear about in a moment, as you've heard, is about private sector prosecution, not government. And that's the difference between the traditional human rights case and today's case. It is private sector litigation using criminal law as well as civil law. So what's the bridge with the private sector? We'll hear in a moment. So desistance is very important. Don't apply bad laws before you get rid of them, and please get rid of them if they're there. Fourthly, don't forget the nature of the state as well as the power relations of commercialism. Many of the interests that you've been hearing about, they don't want you to touch their interests because there is a commercial impact as well as political impact. And very often the two are together. It's the elite at the top that controls the commercialism, that have a vested interest in the company, sitting on company boards. So it really goes together a bit. And we need really to broaden the spectrum to advocate broader democracy, broader peace, broader sustainable development, and broader human rights. And very importantly, we're dealing with power relations, checks and balances. Checks and balances we need to protect people. Maybe media, maybe NGO, maybe us, maybe UN, maybe good judges, maybe good executive, and so on. So don't put your eggs in one basket. Be clever in using checks and balances, please. Use your rights wisely and be clever, astute in protecting yourself is very important. Fifth, SLAPP. The difference between general repressive litigation or prosecution from states is that here we are now faced with private sector operations. And what's the public sector, the government or the judges to do? Do they dare, especially if some of them are linked? Well, SLAPP cases are often affecting silencing human rights defenders, media, journalists, and so on. And you have, as you've heard, a particular impact on public interest litigation, which is different from the general repression in terms of lawfare. as represented by governments. But today, it's interesting that we have another entry point, that's pressure from outside. The European Union, that you will hear about in a moment, has adopted 2 laws impacting on this region. One is SLAPP, anti-SLAPP law of the European Union, whereby companies with establishment in Europe or with tentacles outside, if they're affected by SLAPP around here, you'll get a certain reaction from Europe in terms of countervailing measures in regard to trade. And the newer one, almost the same spectrum, is the corporate sustainability due diligence mandatory, whereby big companies operating in this region with a foothold in Europe or vice versa will have to do human rights impact assessment, including on SLAPP, ultimately, which may lead to consequences in terms of anti-SLAPP measures, but with extraterritorial reach. Whether you like that or not, it's happening. And I'm not necessarily a sort of unilateral person. I'm a multilateral entry point. But that's happening, so be careful. And you'll hear about the anti-SLAPP directive more directly in a moment. 6th, who are the stakeholders? At least 5. So you have leveraging with at least 5 entry points. Please don't put your eggs in one basket. Number 1, the government and different ministries. Different ministries. Number 2, the business sector, good and not so good. Number 3, the judges or alternative dispute settlement. Number 4, the victims and civil society. And number 5, everybody else. We have consumers, because it's a business relationship. What does the consumer wish to do to help, if at all? We've not raised that yet. So it's quintupling exercise that we have to look at, not just one egg in one basket. 7, let's look at the possible leverages from the quintupling exercise. Business sector, good business can help to leverage. Work with chambers of commerce to peer leverage against SLAPP. Work with policy from chambers of commerce against not so good private sector that would use SLAPP. You can also use some means of dialogue, self-regulation maybe, not alternative to good laws, but still may help a little bit. And now, as I said, you have business sector due diligence coming in as pressure from across regions to counter SLAPP. 2, the government. Well, SLAPP can involve government, but often the cases we're looking at are in regard to private sector. So what can we use as good government to help out? Reform criminal defamation law or desist from using it, please. That's what the government should do. Ministry of Labor, we're linked. Ministry of Labor often gives certification for good practices from the private sector. Use anti-SLAPP as a criterion for listing or non-listing companies as a tax incentive as well as disincentive if they do something not so nice. What about the victims in that quadrupling exercise? Well, be careful, as I said, because freedom of expression is not absolute. Be clever. I am not necessarily clever at all, but my reports, my articles almost never mention any names publicly. I avoid defamation. If I mention names, it's behind the scene. I negotiate behind. You can look at my most current report for the UN. There's no name. It's all by implication. And if I do mention name, I go behind. Or I use another channel. Be astute. And if something happens, you need legal aid and assistance. We need to build that to help victims. And of course, there's limited legal aid and assistance on many fronts. And very sadly, of course, affecting particularly women's human rights defenders. Finally, what about consumers in that quadrupling? Consumer boycott can take place, actually, if you look at it. Labeling, encourage consumer lobbies to label products as anti-SLAPP. You buy the anti-SLAPP products, proven. Choose products which are empathetic towards human rights. 8, what if there's no remedy at the local level? The way that you've survived The way that I have to operate is often to go up top to the UN as check and balance. And it doesn't always work. There's no remedy for everything tomorrow, but you must use every lever you can to leverage. Show the preferred way. That is also a part of justice, rather than being shut up, stopped by the abusers. And that's why if you can't claim here, you can claim through the UN. Send complaints to UNDP, please. Have a help desk. And if UNDP doesn't want to do it, refer it to OHCHR or others, the special rapporteurs. I get complaints all the time, and I act on behalf of people under my humble mandate, quietly first, and then very publicly, through press statements, through communications behind. It doesn't always work, but it sometimes works, and it is documented. And it goes right up to the top of the UN system. So use whatever you can as a means. 9, judicial. You can hear it in a moment, but I also work with the judiciary because I teach judges. Now, the interesting feature in Thai law now is that we've changed our law to go anti-SLAPP, but it doesn't work very well. Okay? We've reformed our criminal procedure law, section 161/1 and section 165/2, to screen out SLAPP cases with the help of the judiciary. But does it work? Does it work? Listen to this. 1, there are 3 stages of operations. Institution of proceedings, then pre-trial, then the trial stage. That's what you have to work with, different entry points. Article 1611 particularly concerns the institution's proceedings. And at that moment when you're gathering evidence and so on, if it comes to the judiciary or maybe the prosecutor, they can screen it out. If the judges do some homework in terms of checking the information. But they're not used to it, because the Thai system is accusatorial, it's not inquisitorial, meaning it depends upon litigants, lawyers, making a case for the court, rather than making the judge do the work. So if now we're moving towards inquisitorial system, we need to build a capacity with teams to help the judges reshape their methodology, but it's not done yet, and they need to be trained as well on that one. 2, pre-trial stage. Pre-trial stage to screen out abusive cases, unfounded cases. Previously, the law was that when it's formalized at the pre-trial stage, it was only the plaintiff or only the accuser that could provide the evidence. Today, the defendant or accused can also provide evidence. But you must be clever. You must have a good lawyer, find one, who's succinct, who's precise, who gives information, not long-winded, judicial paper, 2 or 3 pages, clean out the case. The judge doesn't have much more time than that for pre-trial. Not quite there yet, but it's a possibility. And 3, trial. Now there, you'd have much more debate, and you'd cite the substantive laws, cite limitations of the UN on freedom of expression, and make sure it's reason, etc. Hopefully to screen out the cases there and then. And then 4, which judiciary? Currently, the judiciary in this country is an old judiciary, but there are different judiciaries. You have admin court, you have criminal civil court, you have constitutional court, you have military court. And the most efficient one on expedited proceedings is the criminal court, dealing with political cases. That's the one that has expedited procedures. So my solution is this: why don't you shift your SLAPP cases to the court on political cases? That's the easiest one, rather than emburdening the rest of the judiciary with 1611, 1652. That's a proposition. Do it easy, cross-refer, as well as train accordingly. And my last point is this, it's point 10. UN, you spend so much time on conferencing on SLAPP and doing reports. I think every time you spend money on all this, and it's very important here, you should put the same lump sum into legal aid and assistance to help defendants and the accused. That's your moral responsibility. And I say that because I'm pro bono. I'm here to help. I've been helping for nearly half a century. And the spirit of assistance will always be there if you have humbly an element of empathy for what we seek to do. Thank you.
Thank you, Professor Vitit. I wouldn't try to summarize all the important points that Professor Vitit has mentioned to us, other than to say that we all have got, we can use different points of entry to leverage and to address the issue of a SLAP. So I will move on to our third speaker, Mr. Joe Hironaka. He's the advisor and chief of unit, as I mentioned earlier on, with UNESCO office in Bangkok. He has had various positions and addressed current issues in UNESCO on media development, freedom of expression, safety of journalists, documentary, heritage, etc. So Mr. Hironaka is a graduate of Harvard University and Johns Hopkins University. So Mr. Hironaka, can I ask you to speak about effective legal and policy measures within the region and globally to counter SLAPs, as well as existing support mechanisms to aid SLAP victims and the impact of digital technologies and cross-border litigation? Thank you.
Thank you very much to the organizers and really for the level of interest in this subject from this distinguished and learned audience. I hope you'll credit my sincerity. It's really the honor of my life to actually follow Ajahn Vitit as a panel speaker. And I hope I also may benefit from sort of a wave of sympathy for having been put in this situation. So please be ready for a somewhat different level of erudition and charisma and gravitas. And also Chutima, we've followed her case. I followed her case for more than a year. And there are a few more courageous or principled people in journalism or in any other profession, so it's really an honor. I'll be speaking about SLAPs from the perspective of UNESCO. And the many member states, including some in this room, supporting our work on SLAPs, on the Global Media Defense Fund. But I will start with a bit of relevant historical context on freedom of expression in general and the Universal Declaration of Human Rights, which is that if you actually look at the origin of the UDHR, France, where my organization is headquartered, is where it was adopted, right? It wasn't adopted in San Francisco or in New York. And part of it was that UNESCO convened the leading world philosophers and religious leaders, including Gandhi and so on, to try to bridge a common understanding of human rights, to rally around the Declaration of Human Rights draft. It was a new instrument on human rights, and that's why countries like Thailand, Siam, Burma, Indonesia, India, and the Philippines are original signatories of the UDHR. And you hear that a lot, original signatory, but what does that actually mean? It means that Thailand, Indonesia, and so forth adopted the Universal Declaration before Switzerland, before Germany, before Japan or Korea. You can go to the UN General Assembly. I worked there for